by Saurav.
Led by Saurav.
Okay. So you are appearing in the second matter.
Second matter.
Yes, Mr. Mahapatra, you are the petitioner in the opposite party in the first matter, the petitioner in the second matter. What do you say?
My lords, let this matter reach, my lords, because this is a matter where your lordship remembers the decision of the division.
After the matter reaches, I will say that nobody can appear for the other side.
No, my lords, this is not.
Sir, what kind of submission you are making? You must understand the context what you are saying.
My lords, your lordship.
If they are appearing, I'll prevent them from appearing. I'll record that since Mr. Mahapatra says no one will appear.
No, my lords, they are appearing, my lords, in the first matter. It is a case where the husband has filed.
Anyway, it let it reach. You have seen your colleague, so he doesn't follow what you are saying, or at least I could not make him convince.
My lords.
My lords, item 2.
Yes.
On behalf of Mr. S.P. Sarangi, my lords, kindly be taken up after 2 weeks.
କୋଉଠୁ ଆରମ୍ଭ ହଉଛି କଣ କିଏ କହୁଛନ୍ତି ତାର ମାନେ what's your name, sir?
Abhilash.
Mr. Abhilash Sodangi, on behalf of SP Sodangi for the petitioner. The defect, the matter was taken up before the item 2 election. Don't miss the serial. Listed before the registered Deputy Register Judicial Law JIMA on 28/10/2025 for removal of defects. Thereafter, by order dated 31/2/2026, the matter was adjourned, granting time for removal of defects, directing the matter to be listed on 28/2026. Now, on 28/2026, the matter was again adjourned, granting further time, granting 7 days time, directing the matter to be commencing 4/2/2026. On 4/2/2026, the matter was adjourned. Again, at the instance, matter was adjourned again, granting further time. Stop. The matter was again listed on 12/2/2026. The matter was heard at length.
Yes, sir.
And adjourned at the instance of the learned counsel for the petitioner. Expecting him to address on the issues as noted in the order dated 12/2/2026. The matter is listed again today. Adjournment is sought for on behalf of the learned counsel for the petitioner. To grant further opportunity, how much time, sir?
2 weeks.
List election. 2 weeks के बाद date करंतु. List in the week commencing 30. Yes.
Item 4, Miller. I pray for an adjournment because I have to obtain an
instruction. Agur कितना list है
thorough list I have to obtain the status of the civil proceeding, Miller, which is pending before the Judge Family Court Puri. Because there is a case of 2023 and the order which is under challenge is of the year 2024.
एटा किछि तो order हेनी आपनकर
पूर्वरु thorough list and that is
3076. The order sheet doesn't show. Posting कर दियंतु केबे Mr. Tripathi?
2 weeks after any date.
We counsel.
Yes.
My lord, item 5 and item 9, my lord, on behalf of
5 गोटे जाऊ आपनकर
item 5, my lord.
5 आपनकर ना सर?
My lord, Spandan Srichand, S. Srichand.
कौन चाहूचंदी?
My lord, I pray for an adjournment.
The learned counsel for the petitioner was harder. You are Mr. Parth Agarwal.
No, my lord, I am S. Richardson, ma'am.
Mr. S. Chandran for the petitioner. And for the petitioner, adjournment is sought for on behalf of the learned counsel for the petitioner. Earlier, on 24/2/2026, the matter was heard at some length and was adjourned as sought for by the learned counsel for the petitioner to address on the issue as noted in the said order dated 24/2/2026. Stop. As paid for list in the week commencing 6/4/2026. Yes, next.
Page 2, 7 to 68.
Item 9.
9. कौन है सर 9 ले?
Lord, praying for an adjournment on behalf of Mr. Acharya.
तेरा पर ना नहीं.
No, my lord.
So it's chosen on behalf of Ramdas Acharya for the petitioner. Item 9. Order लिखा. Yes, next. अपन लिख दे अपन पोस्टिंग कर दे ऑर्डर द फैक्ट. Yes, next.
Page 3, 17 to 23.
23, my lord. Can I take up nesting, my lord? I am appearing for opening of
23 को कर दिया तो
We commencing short.
next week, my lord. Can my lord is senior? It is appearing for petitioner, my lord is senior Mr. Jakirat, my lord. He may be.
you want adjustment in the next week. वो week 16 week रे चाहछन्ती ना 9 week.
Anyway, any date, my lord, next week.
से 6 के 16 डेट करछ. से आफ्टर नोटिस जति अछि लिस्ट ताको देखि करछन्ती.
Saturday, my lord. Earlier, my lord.
तो अर्लियर कर दियंतु केबे हे परियो.
Oblige, lord, sirs.
Item 17.
आगे
17, I have filed a objection. One of that.
अदर साइड पड़े गले पण ऑर्डर्स ता ऑनर का एब्सेंस से मेंशन करछन्ती. कोन जदी रहिबेनी एडजर्नमेंट नेबे काको रिक्वेस्ट करन से कहि देबे आपण गला परे आपण केबे चाहछन्ती एडजर्नमेंट 17 डेट करथा से पडला बेले डाकिबे हैला
30 दिन.
और जदी जिबे जानथा 30 दिन रे आसीबे से वीक रे से राजी होवा दरकार. नेक्स्ट
Pardon, your lordship. Lordship, item number 19 and 20, your lordship.
हां 19 20 कोन हैला.
Lordship, and short adjournment, your lordship. I am appearing on behalf of Mr. P. Anup Das for the petitioner.
आपण को ना
Divya Ranjan Barik.
पावन नहीं.
No, your lordship.
Orders matter काहे के अर्जन करछोती could have easily you should argue or at least make some submission before the court.
My lord, sir, I was.
और 19 एक डेट कर दियो.
We commencing 30 दिन.
We commencing 30 दिन कहउछन्ती हैला.
Oblige, your lordship.
Yes, next.
Item 28, your lordship, on behalf of
I see.
28. 28, your lordship.
28 अच्छा. Dakinan, sorry.
24 to 20.
Item 25, your lordship.
Yes, please.
Item 25, I need 4 weeks time to file rejoinder. State is other side.
This item, my lord, 2021, that is a stay order containing for 2016, my lord.
Subject करछन्ती
And
counter-
filed,
counter-
your lordship will perish the order sheet. I have.
नहीं सर मु आउट ऑफ टर्न नेबिन आपण आकर करे बोले मु
Law-
मेंशन केला सब्जेक्ट करछन्ती मते कि कहउछन्ती.
20 in 2025, there 2025, the lordship may see the
सेटा हबो से 16 रे जेतु 9 वर्ष पर काउंटर फाइल करछन्ती सेटा नोबडी कैन टेक एक्सेप्शन.
24 रही 21 ना 22 रही sir. I have gone through.
ठीक अछि से 6 वर्ष पर करछन्ती दिस अचीवमेंट.
Because of the stay order, I have.
one.
आज आपण काउंटर फाइल कला पर स्टे दिया मिस्टर साहू टू टॉक सेंस as if the court has adjourned the matter.
Also, sir,
When did you file the counter?
counter in 2022 or
22. When the stay order was passed.
Stay order is 16. There is a delay. Yes, I am.
So please don't make a pretension as if the court has granted time.
For the purpose of rejoinder, that is at least 3 years time was granted by the.
No. So that is not. When you take 6 years, how can that 3 years?
So there is already delay.
I'll record that. No difficulty.
But
Last chance.
I mean,
last chance, your lordship.
making the submission ridiculous does that improve the quality of submission, sir. By interjecting the other counsel, and making ridiculous submission.
Last chance, your
Sir, no last chance in appeal notice matter because it is not a case of CPC that I'll reject the pleadings.
Sir, I am.
Sir, don't make ridiculous submission, Mr. Sahoo. Go by law, it is not your personal. You don't identify yourself like with Mr. Sharma, you are fighting with Mr. Sharma. Sir, I am also bringing to your kind notice that when he is seeking adjournment, you are objecting, and the reason is that in a matter that the stay was granted in 2016. So I'll record that when the matter reaches. No difficulty. Who is saying that adjournment is to be granted?
3 ବର୍ଷ ହେଲା rejoinder କରୁନାହାନ୍ତି ମୁଁ ଦେଖୁଥିଲି
ଆପଣ 6 ବର୍ଷ ହେଲା ଦେଉନାହାନ୍ତି କେତେ ଥର କରାଯିବ ଆପଣଙ୍କ? So why are you making ridiculous submission?
I am last chance କରନ୍ତୁ.
Why should I object? I may allow the writ application. I may dismiss the writ application. I will not take dictation from you.
Yes, yes.
So why you decide saying that last chance karantu? You are not given a last chance. How many times you have taken adjournment?
Sir, I am not saying that.
Sir, why are you saying so? I couldn't ask you. Okay.
I am not saying that, sir.
Why are you wasting time, sir? I have already noted your objection and told you. Then why are you going down? And nodding your head for nothing. Why, what is going on? I don't understand. See, the point I object, I said, okay, to not be adjourned. Let it reach. So what is the difficulty? Yes, next. The kitna number item है?
25.
Item 20, your lordship, on
What matter?
Sir, please, sir. Let us.
Yes, sir. Yes, sir.
Sir, kindly just be show some kind of sensibility. You may not show respect. That's a different thing. But some sensibility to the proceeding. Doesn't matter, sir. That doesn't matter. I am not seeking any respect from anyone.
I am not.
Much less you.
I am not. I cannot.
item
sir. ତାକୁ ବି ଶୁଣନ୍ତୁ ତାକୁ କୁହନ୍ତୁ ଆପଣ ସେ ଇଣ୍ଟରଜେକ୍ଟ କରୁଛନ୍ତି ନା କଣ ଚାହୁଁଛନ୍ତି ତାଙ୍କଠୁ ଆରେ ସେ କହିଲା ଆପଣ କହୁଛନ୍ତି ନା
କହିନି ସାର୍
ଏବେ କହିଲେ ତାପରେ
ସେଇ 25ଟା ସାର୍ କହୁଥିଲି
ଆରେ ଆଜ୍ଞା 25 ସରିଲାଣି ଆଜ୍ଞା ସେ 28 କହୁଛନ୍ତି
ନା ମୁଁ 28 ସାର୍ କିଛି କହୁନି
ସେ କିଛି କହୁନାହାନ୍ତି ଆପଣ କୁହନ୍ତୁ
item 28, your lordship, on behalf of Mr. Vijay Kumar Patnaik, kindly adjourn this matter to some other.
adjourn करती हैं
We commencing 4th है.
Obliged, your lordship.
yes next
Page 5, 29 to 38.
Please, my lord, item 32. Seek adjournment, small adjournment.
adjourn कर दियंतु other side दिलीदत्त महापात्र को कहना है अपन
Yes, in the morning court tower.
ऐसे morning नांती he was there very much in the morning
My lords, last chance was. Let's let this matter reach, my lords. On the last occasion, they had.
objecting
Okay.
yes yes next
Page 6, 39 to 40.
yes from the list want to be mentioned कौन रख लेनी 2 p.m. अच्छा yes 3 Mr. R.R. Naik for the petitioner R.R. Naik for the petitioner, opposite party blank. The petitioner is before the petitioner husband in the marriage is before this court. Seeking revision of the order dated for 16/4/2022. passed by the Learned Judge Family Court Jajpur in IA number 7 of 2022, arising out of civil proceeding number 232 of 2020. So, the said IA was filed under Section 26 of the Hindu Marriage Act, seeking modification of the order passed by this court by the learned by the not this court, but the Lord Judge Family Court in IA number 13 of 2020, by allowing the petitioner to visit his son, then aged about 7 years, residing with the mother, who was the OP number 1. Stop. The matter was presented on 27/2022. And was listed on 29/8/2022 for changing the nomenclature. And the matter is today at the beginning of the proceeding, the matter being in the list was mentioned. Memo of date is filed, which states thus: scanned copy be updated. The memo shall be taken. Memo is taken on record. Scanned copy be updated. Stop. Or accordingly, the petition stands disposed of. Stop. Para. Copy of this order shall be forwarded to the Learned Judge Family Court, Jajpur, to be kept in the records of CP number 232 of 2020 and /or IA number 7 of 2022. Yes. Next.
Item 6.
Yes, Mr.
Please, madam.
So the item first matter is Mr. Saurabh Tibrawal for the petitioner, TRPC 14 of 2026. Mr. Devidatta Mahapatra for the opposite party. Yes, next. Yes, please.
I want to have a glance to order dated 19/1/2026 in that case.
Mr. Khandelwal. Mr. P. Khandelwal.
Yes, Your Lordship.
Not Tibrawal, Mr. P. Khandelwal. Yes, Mr. Khandelwal.
Lordship, I'm only praying for the time, Your Lordships. In the second case, we are
Learned Counsel for the
SCP notice.
Yes, which paragraph, Mr. Tripathi? Mr. Mahapatra, I'm so sorry, Mr. Mahapatra.
My lords, your lordship may have a glance to paragraph 4-5, my lords. This matter, your lord, this adjournment, your lordship may note the reason, my lords. There was a specific direction in that matter.
This order was not, you were not heard.
No, my lords.
Before you appeared.
My lords,
Yes, so he has to address on that.
Because
the decree was the ex parte decree was set aside, then it was remanded. Can you read para 5 para 4 onwards? Get the context.
Chief, only difficulty is, Your Worship, Mr.
No, can you read that?
Obligation. While approaching this court, the petitioner appellant had brought to the notice of this appellate court regarding pendency of Section 9 application, that is CP 867 of 2022, before the Learned Family Court, Bhubaneswar. The division bench of this court, by order dated 19/12/24, had allowed the MATA 286 of 24 with the following observation.
Yes.
It is apparent from the para 5 of the said order, Your Lordship. It is apparent from judgment itself that there was a direction made not finding basis in any evidence adduced. It is sufficient for us to, without going into any other issue decided by impugned judgment, direct remand for rehearing. Para 6, impugned judgment is set aside in appeal with a direction for remand. The direction is made under Rule 23A of Order XL of CPC. We have ascertained that the restitution case is still pending in the Family Court, Bhubaneswar, considering the petitions were disposed of. Because there had been judgment in the matrimonial case prosecuted by respondent in the Family Court, Sambalpur, respondent may either defend the restitution case in the Family Court, Bhubaneswar, or a petition afresh for its transfer to Family Court, Sambalpur. On omission of respondent to do either, it must be duly considered by Family Court, Sambalpur. Para 5, it is further submitted and brought to the notice of the Honorable Court that pursuant to the liberty granted by this court, in the said matter, the opposite party wife had filed TRPC 22 of 2025, which is pending adjudication. Notice have been issued and the next date of listing is in the week commencing 23 to 26.
You have stopped reading.
Para 6, Your Lordship, in
You don't have to say paragraph 6, take a lot of time there. Go on reading. In considered opinion of this
in
court.
considered opinion of this court after the direction by the division exercising the powers of the appellate court under Rule 23A in order 41 of the CPC, Your Lordship, setting aside the ex parte decree and remanding the matter to be considered by the learned court in session, that is the learned judge, Family Court, Sambalpur. The said order cannot be further modified. Further, this court sitting single would not have any such power. Coming to para 7, Your Lordship, however, adjournment is granted sought for. The present TRPC shall be listed along with TRPC.
So yes, Mr. Tripathi, what do you say? In the second matter 22, now it has gone to your the ball is in court. 22, yes, what you are saying?
Under 22, this is an application for transfer of that restitution case to Sambalpur, my lords, in view of the liberty granted to me, my lords, in Mata.
Correct, Mr. Tripathi. Now the question is, after the decision bench directs to file you a petition, is it a mandate on the court to allow that or consider that?
My lords, consider, my lords, consider.
So now for that to be considered, if a lawyer is engaged, what would be the next step by the court, according to you?
No, my lords, because in that...
This answer, no, my lords.
My lords, I am answering, my lords.
22, as per the direction, liberty granted, you file 22.
My lords.
Is the issue. The lawyer is present and he says that they will appear. So what order can be passed? You will say no, my lord.
That is not my submission, my lord.
You are, I don't know, today morning after yesterday's only something has happened. Simplest of thing, this going on and on and on. When he said that I seek, I will be filing Wakalatnama, you wanted that this matter should be taken up. Now the matter is taken up.
My lords.
So now you have stopped saying anything.
My lords, your lordship, if is inclined to grant.
No, not inclined, sir. I am asking you.
Because the matter was supposed to be heard at Sambalpur.
This is not your, you must understand that what you are saying.
My lords, if the matter was supposed
to can you develop a habit of listening and then answering?
My lords, I beg apology, my lords.
I beg a real apology because you have understood that. You are answering without listening. What is the question to you?
My lords, that whether they can appear in that case or not, my lords.
Is that the question? You what you said. In 22, now you have said that you have moved 22 as per the liberty granted.
My lords.
22. So notice issued.
My lords.
So after notices are issued, then so I asked you that whether because you have filed a TRPC, it will be allowed or it has to be considered. Then fairly you have said that obviously with welfare it has to be considered. So now they say that they will appear in 22 and file their response or whatever they may concede. I don't know. Even you cannot know unless you have talked earlier and pretending this kid glove battle. Kadi kusti joda kahan sala kusti bhi achi. So at times because now the matter being live, so that also creates impression. So now after the notices are issued, he wants to appear. So you are objecting that to adjournment for 2 hours. So what order can be passed?
No, my lords, I'm not objecting for an adjournment. I wanted to bring the last order to the notice of this court, my lords. That was my.
So now he has placed spend time, not required actually. But since you are objecting, so last order noted that there is a liberty.
My lords.
Correct?
There was a liberty.
Last order noted that 22 is there.
My lords.
22 now.
And they had the occasion to appear in the meantime, but still they're seeking time, my lord. So lordship may fix up any other day as per their convenience. I
So that yesterday both of you have played Holi together and decided to do this today.
no, my lord.
Actually, this is in true sense of Holi, that fun fair. You stay in Bhubaneswar.
At Cuttack, Your Lordship.
So he comes to Cuttack, that's for sure.
I'll be there at 2, even if I'll be there at 2 p.m.
Whatever.
Sure. 8 may fix, Your Lordship.
No, actually he's not objecting because it is his interest that you appear. That is how I made you to read the order. It is not that I did, because I have passed the order, I understand what is the order. I have simply noted that the court has granted liberty, so he has filed 22. প্রথমটা লিখছেন দেখুন TRPC 14 of 2006. Mr. Khandelwal for the P. Khandelwal for the petitioner, Mr. Devidatta Mahapatra for the opposite party. The learned counsel for the petitioner refers to the order 18/12/2025. Say order submits that as directed in the connected TRPC 22 of 2025. As directed, no, as observed. Next, I have started mixing up. I have mixed up the orders actually. That's correct. Refers to the order dated 19/1/2026. Passed in TRPC number 14 of 2026. Stuff. In the said order, it was noted that TRPC 22 by C of 22 of 2025 has been filed by the opposite party wife in the marriage seeking transfer. Mr. Mahadev Mahapatra, Koti.
Bhubaneswar to Sambalpur, my lords.
You can transfer the CP number CP number 867.
My lords, 867.
So English is 867 now.
My lords, of 2023.
CP number 867 of 2022. That's pending before the Learned Judge Family Court Bhubaneswar to the Learned Judge Family Court Sambalpur. Stuck. The said TRPC 22 of 2025 has been tagged to the present brief case and has been listed together. In the said matter, it is submitted by in the said TRPC, the matter of TRPC. By C of 2025, it is submitted by the learned counsel, Mr. Khandelwal, that Mr. Saurav Tibrewal, learned counsel and learned associates have instructions to appear.
Yes.
They shall file wakalatnama. How much time, Mr. Mahapatra, you will allow?
My lords, as your lordship feels, my lords.
I'm very much pleased, sir. It is as you will decide.
That's 1 week.
How much time?
Next week, Your Lordship. I don't know.
You prayed for 1 week. He's so pleased he's giving 7 days. He paid for 1 day actually. Well, this will file duly executed wakalatnama within 5 working days.
Yes, Your Lordship.
The wakalatnama shall be taken. Sir, most crucial part of advocacy is filing of wakalatnama. That you are objecting.
No, my lords, I'm not
Most
objecting.
crucial part.
I'm not
Apart from authorization, it sets the ball in motion. Apart from that, it has so much significance.
my lords.
All right. 5 working days upon filing of the wakalatnama, the same shall be taken on record and be updated. Hello. The list in the week commencing, both the matters shall be listed in the week commencing. नहीं महापात्र को हम ऑब्जेक्ट कर अपन 30 दिन he is not he is as good as he is not listening also 23 दिन हे परिबो 23 दिन दे केतेला कट कर दिछंती 76 टा मिस्टर महापात्र 30 दिन से कहछंती काना 25 टा मैटर से अपन पोस्ट करछंती ना 23 दिन
What is convenient, my lords?
then I am very convenient 23 दिन is very convenient also so 77 हो सेतरा more inconvenience कोन अछि list in the week commencing page 3. For understood though. Na kana fresh admission notice issue ହେଇଛି. These are the notice sufficient ହେଇଗଲା.
Yes, Your Lordship.
Both are notice sufficient now, Mr.
No, my lords. In TRPC 14 of 2026, no notice was issued. I have appeared voluntarily, my lords.
Is it?
My lords.
Then I have missed that. ठीक है चल 14 आगे ऊपर लिखियो पड़ियो नोटिस इशू इन क्वेश्चन
I have appeared voluntarily.
तापर जो 14 आपण लिखचुंती गोट हैला कि लास्ट एडजर्नमेंट डेट लिखचुंता सेटा लिखिबे इशू नोटिस पारा since Mr. Mahapatra, Mr. Debidatta Mahapatra and learned counsel and associates have appeared. Have already entered appearance. No further notice be issued. Copies are paichanti apana?
No, my lords. Copy be served.
The application shall be served on the allotted ଆପଣଙ୍କ associate ନେବେ ଏଠି ଅଛନ୍ତି ଏବେ ଅଛନ୍ତି?
My lords, even if I'll be there at 2 p.m., my lords.
Copy of the petition shall be served on the allotted counsel for the opposite party today.
Yes, Your Lordship. Provide.
During course of the day, as it is submitted by Mr. Mahapatra that he shall be available after 2 p.m. before this court. तापर डेट पोस्टिंग डेट कर देना तापर लिखिबे नेक्स्ट TRPC 22 of 2025 as observed as directed by order dated 19.01.2026 the matter has been listed along with the TRPC 14 of 2026 it is submitted by the learned counsel Mr. P. Khandelwal that they have instructions and I repeat copy paste for them. Khandelwal that Mr. Saurabh Tibrewal learned associates along with his learned associates shall appear they shall have instructions to appear on behalf of the opposite party. He seeks further time to file wakalatnama. Stop. Accordingly, the duly executed wakalatnama shall be filed within 5 working days. On filing of the wakalatnama, the same shall be taken on record, scanned copy be updated. Name of Mr. Tibrewal, Mr. S. Tibrewal, Mr. P. Khandelwal and associates shall be list as well as the case brief appearing for the opposite party. List in the week list along with so and so. Yes, next.
So the typographical error which has happened, my lords, I beg pardon. Instead of 2022, it would be 2023, 867 of 2023.
Co-order
फास्ट ऑर्डर रे डाकला को 867 of 2022 है ये सर 2023 सीपी नंबर टा 022 जाने it will be 23
लिखंतु उधरे TRPC 14 ने लिखिए at paragraph 4 सभा ऊपर लिखिए at paragraph 4 of the order dated 19/20/26 any other reference को थी मिली बा सीपी रा
minutes may come to my TRPC. That is 20. Your lordship may come to my TRPC minutes 22.
867 2023 से ठीक अछि आपण दिन आर यू श्योर
Yes, your lordship.
ठीक अछि त ताल चेर लिखि दबा
CP 867 or 20.
और लिखि हां paragraph 4 of it the at it has been in the third line it has been mentioned quote कर देबे CP number 867 of 2022 quote ends it is submitted by both the lauded counsel for the appearing parties that CP number is 867 of 2023 stuff accordingly necessary corrections be carried out in the said order in order dated specific order dated 19/1/2026 paragraph 4
And the interim order to continue in TRPC 22.
22 रे interim order थिला the interim order dated interim order dated 11/2/2025 shall continue till the next date of hearing. Yes, please.
Obligation.
Item 7.
May I please your lordship? The petitioner before your lordship.
So Saroj Kumar Padi for the petitioner. Yes, please. Yes.
Lordship, the petitioner before your lordship seeks kind intervention of this honorable court for transfer of matrimony case number 51 of 2025 pending before the court of Honorable Senior Civil Judge Sundargarh to the court of Honorable Judge Family Court Balangir, lordship. Ground your lordship, I am having a kid of 7 years. Moreover, it's
7 years kid, I have already decided that having a kid cannot be, because I cannot allow the kid to be transported to the court.
lordship.
If you are submitting that, you will carry the kid to the court, to the Balangir or Sundargarh, that cannot be allowed.
Lordship.
Neither it can be allowed that the court should be held at the place convenient to the kid.
Lordship.
Consideration.
Distress lady, your lordship, more than
appearing that you want Sundargarh to where?
Balangir, lordship.
So how appearing that Sundargarh is stressful and Balangir is not stressful? So that's that. That I have to do again justify in my order. It can't be the individual choices of a particular, because section 19 of Hindu Marriage Act is not that. There is no provision. How many cases he has filed against the husband?
Only one case is that is for restitution of conjugal rights at Balangir.
Are you sure? I have obtained instruction.
Lordship,
He has not mentioned any other domestic violence. 498A.
Filed your lordship. I have obtained instruction. Only that is CP matrimonial number 2 of 2026.
When did she file?
After receipt of this first one divorce notice in the court of...
So that is more so to reject the prayer. Once you receive notice in a matter, you start initiate another proceeding. Rather, these proceedings should be transferred to that court to be taken up together. Some German cause provided in Hindu Marriage Act, Family Courts Act, or any case law, that the wife will decide the place of litigation. I have whatever little I have tried to read and understand, I have not found anything. And the other problem is now by transferring the expeditious disposal, which is a mandate, which is required. And when there is a lot of discussion that matrimonial matters should be kept pending. So it goes to the list of 2026 matter. It is already pending since 25.
Lordship, though I do not carry the judgment, Your Lordship, I have relied upon one case law, Your Lordship. I have mentioned
No,
it
sir,
12.
Obviously, if you as a lawyer, you have to be updated with your case law so that we can discuss. Because you are now second guessing it. The points you have taken are in any case law. Having a kid and choosing to file a case and then seeking transfer of the earlier matters.
Dependent lady, Your Lordship, upon his
No,
parents.
then I have to record that for prosecuting at Sundargarh is less stressful. That I have to give some reason.
The petitioner does not have any come to travel, Your Lordship.
Sir, I could not hear you, sir. I put a microphone down for you. I think वो तो बहुत बड़ा पटरे को उतरी कौन कहले सुबिलानी sir.
The petitioner is a distressed lady residing with her elder parents, Your Lordship, who are senior citizens, and at Balangir she is now staying. The CP has been filed by the husband at Sundargarh, Your Lordship.
What is the stage of that CP? That I do not know.
Notice has been issued and the present petitioner is respondent as the appearance there, Your Lordship.
Has entered appearance?
Entered appearance, Lordship.
Then it has been referred for mediation counseling, statutory counseling.
No, in fact, it was posted to 7th February 2026 for filing of so calls. My lord, page 28.
No, I'm not asking the page. The question is very specific. Has it been sent for counseling between the parties? Because there is a mandate of the statute.
That information I do not have, Your Lordship. Right.
The Saroj Kumar Padi for the petitioner. To take your seat, I'll dictate the order. The petitioner wife in the marriage is before this court seeking transfer of the CP number, MAT case number 51 of 2025. Pending before the learned judge, family court, Sundargarh, to the learned judge, family court, Balangir. Correct. Yeah. Balangir. So, apparently, notices were issued in the said CP by the learned judge, family court, Sundargarh on 9/10/2025, fixing date of appearance on 12/11/2025. It is submitted by the learned counsel for the petitioner, wife in the marriage, that the wife has appeared before the said court pursuant to the notice. Stop. Thereafter, she has filed CP C.P. into bracket MAT number 2 of 2026 on 2/1/2026 under section 9 of the Hindu Marriage Act. Before the learned judge, family court, Balangir. Stop. It is submitted that maintenance allowed 125.
Correct.
I'll record, sir.
I have the instruction while I filed.
Something asked the learned counsel for the petitioner submits that as per his instructions, as per the instructions received from the petitioner. The petitioner has not filed any other case, any other criminal case making any allegations against the husband, nor she has filed any petition seeking maintenance from the husband. Stop. But it is submitted by the learned counsel for the petitioner that petitioner is distressed and she stays after her marriage. Take your seat. After her marriage ran into rough weather, she stays with her parents at Balangir and is has difficulty to appear before the court at Sundargarh. Issue notice along with regarding on being asked whether the parties have been referred to counseling as mandated by the statute into bracket Hindu Marriage Act. The learned counsel for the petitioner submits that he has no instructions regarding the same. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. IA 32 of 2026. Heart learned counsel for the petitioner. He reiterates his submissions as noted above. Para issue notice along with this order. Notice TRPC. Stop. Accept one set of process fee as well as the postal requisites. For जो अपना notice file you लिखते हैं, returnable date be fixed आज कितने तारीख है? Returnable date be fixed to fixed to 6th of April 6/4/2026. ना वो जो लिखने 6th April करेक्ट तापर लिखिए लिस्ट इन द वीक कमेंसिंग 13/4/2026 ହେଲା এটা আইএ রে লিখিবে in the interim it is directed that the pending proceeding তা কথা হচ্ছে MAT case number 51 of 2025 pending before the Lord Senior Civil Judge Sundargarh. ऊपर correction है ऊपर में family judge है pending before the Lord Senior Civil Judge Sundargarh shall be adjourned to a date beyond 20/4/2026 on a prayer being made for that behalf. For the said purpose, upon a prayer being made for the said purpose before the Lord Court, so the adjourned date shall be fixed as per the minutes of the Lord Court in season of the matter. Yes.
Obliged.
Yes, please.
Item 8.
May I please, Your Honor?
Miss MS Rita Singh for the petitioner. Yes.
The transfer of civil suit, my lord. One IA has been filed, but that has not been reflected in the cost item nor in the file, my lord. IA are reflected.
Can you do you know the number? The number जानना है
Number तो मुझे लिखी नहीं number भी
ठीक अछि केबे आसिले हबो ताले
Tuesday दिन से
Tuesday पूछन
हाँ 10
we commencing
10
9 तो ठीक अछि. It is submitted by the learned counsel for the petitioner that IA filed by the petitioner has not been tagged. This 6 adjournment upon trace करी पारिबे तो वाले फेरे C6 adjournment to take steps for tagging up of the matter. Tagging up of the IA, the TRPC. List in the week commencing no March 2026. So, take steps for tagging up of the IA stated to have been filed. Date तारीख भी जानना है ठीक है stated to have been filed by the petitioner along with the TRPC. Yes, please next. हाँ ताको से कर दी चंदे ना
item 10
नाड़ा कौन भूली वाली
yes
हाँ Sichondan, Mr. S. Sichondan.
Yes.
Yes, next please. So V. Mahapatra. So V. Mahapatra for the petitioner.
Challenging the order of the permanent local Adalat under Annexure 1, my lords.
Have you checked the case law on this?
My lords.
So I'm keeping the issue of admissibility and maintainability open, issuing notice. Okay.
Plus
So
item 10, my lords. Plus item 10, I have instruction.
Take your seat, I'll dictate the order. The petitioners are consumers.
Plus item 10, my lords, I have instruction to appeal on behalf of the opposite party, my lords.
The petitioners are consumers. The petitioner, plural, no, singular. The petitioner is a consumer of electricity. Stuff C6 to challenge award dated 29.10.2025 passed by the permanent Lok Adalat into bracket public utility services bracket closed comma Puri in PLA all capital PLA case number 61 of 2025. Stop. By the said order, PLA had the PLA, comma Puri has directed the lauded PLA, comma Puri has directed the petitioner to pay a sum of rupees 36,633.50 towards arrears of electricity dues. Scope of interference. Hard lecture hard direct petitioner. He seeks issuance of notice to the opposite parties on the ground that Mahapatra, you are appearing here. Somebody is appearing. It is item 10. Or he is your colleague?
No, man.
Data power lekha
Malas item 10, malas, I have instruction to appeal, malas.
Okay. All right. That the PLA had no authority, they had no jurisdiction. And the order passed is contrary to the statutory scheme. You sit down, he is sitting, you also sit. What is difficult? He may be less comfortable also. The AC is better. Only. Passed is contrary to the statutory scheme, that is Legal Services Authorities Act 1987. Stop. Interference by this court in orders passed by Lok Adalats has been subject to adjudication before the Honorable Apex Court, and several directions come out. No, and the law has now been settled by the decisions rendered in State of Punjab versus Jalor Singh. Citation, tapore Bhargavi construction. The third one is issue notice on the question of admission and maintainability of the application. Stop. Along with this order. Stop. No? Along with this order. Then stop. Mr. Sarthak, you are
on behalf of LK Maharana, my lords.
Mr. LK Maharana, Lalit Kumar Maharana, Learned Counsel. Mr. Sinandi. Mr. Sarthak Mahapatra, Learned Counsel, is present in VC. Stop. He submits that Mr. Lalit Kumar Maharana, Learned Counsel, along with Mr. Sarthak Mahapatra and Learned Associates, have instructions to appear on behalf of the opposite parties. How much time? Wakalatnama pai?
Wakalatnama will file in the next week, my lords.
Okay. Stop. It is submitted that Wakalatnama, duly executed Wakalatnama shall be filed within 5 working days. No, 7.
My lord, 7 working days.
Within 7 working days. Stop. Upon filing of Wakalatnama, the same shall be taken on record, scanned copy be updated. Stop. No further notice be issued to the opposite parties. Mr. Mahapatra, Mr. V. Mahapatra, you can file soft copy. Copy of the application along with annexures and other connected papers shall be served on the who will receive Mr. Mahapatra here.
My lords, I'll receive, my lords. I'll share the contact number of the clerk, my lords.
Shall be served on the Learned Counsel, Mr. Mahapatra, appearing along with Mr. Maharana for the opposite parties. How many copies?
My lords, 2 copies, my lords.
For their office and 2 copies. List, this is for orders or admission? List for admission. For orders as level. Yes, what do you say? Should it be listed for fresh admission orders or for admission?
My lords, fresh admission.
Because prolonged hearing will be time consuming hearing is impacting the entire list.
My lords, fresh admission, my lords.
Okay, upon the appear colony, kahi fresh admission chahuchandi. I could not follow you, sir.
Sir, orders tale asu, sir. Orders asu.
Orders asu. You accept. You also walk through a few steps. The matter shall be listed for orders in the week commencing. What is of the time deve dangala? Upon object ko nante aji wakalatnama file kare both objection hochi. Today we have to that. Take 13 4. 6 4 ରଖୁନାହାନ୍ତି 6 4 ନା 13 4 କୁହନ୍ତୁ
6 foot
6 4 ସେ 6 4 already 21 ମ୍ୟାଟର ରଖିଦେଇଛନ୍ତି 13 4 ରେ ଅଛନ୍ତି ଗୋଟେ
so
that is how he is managing he has some limitations
then me keep it to 13
we commencing 13 4 ଥାଉ ଆପଣ ବହୁତ ସମୟ ଲମ୍ବା ଚାଲିବ ଆପଣ ଦେବେନି ସେ 36000 ନା କେତେ ଟଙ୍କା ଦଉନାହାନ୍ତି କାହିଁକି
problem
these are the classic cases where mediation will help
that
or even if you come before this court has no jurisdiction
in this
matters you need to sit back so you can convince
in this case consolation
so I can tell him that you accept 30,000 that would be the best approach by keeping this matter pending another 2-3 years 4 years
even in conciliation the petitioner agreed to pay. But without discussing if the conciliation failed or passed the...
Correct, sir. You take approach. You take a conciliatory approach. Tell the court. I'll tell them. They will consider. I'm sure it will be worked out. Yes. Yes, please.
11.
So I have filed an IA in this matter, my lord, sir.
Disconnection.
No, my lords.
Disconnection.
Disconnection has already disconnected, my lords, but PL has directed me to pay the amount to the.
IA simply notice issue sufficient. So you are IA 1849 of 2026 set add jota achi. Upon jota even 10 ta likhile. Hard Learned Counsel for the petitioner. Issue notice है जाबो. है ना तापर लिखिए in view of submission made on behalf of the opposite parties that Mr. L.K. Maharana, Mr. Sarthak Mahapatra, Learned Counsel and Learned Associates shall appear on behalf of the opposite parties. No further notice be issued. Extra copy of the IS shall also be served along with the WPC. Copy of the WPC on the Learned Counsel for the opposite party within
within course of the
during course of the day. Yeah. Uparvisha during course of the day. This next.
Obliged. 11.
My please, Your Lordship. This is a writ application challenging the.
You are Miss Prakash.
No, I'm Miss Mishra. Anvesha Mishra.
A. Mishra.
A. Mishra.
Amisa.
Anvesha.
Anvesha. Miss Anvesha Mishra for the petitioner. Mr. P.K. Mohanty for the opposite party.
Well, this is a writ application challenging the inaction of the opposite parties in non-issuance of the ration card, my lord. Ration card was first issued to the petitioner on 26/10/2015. My lord, may kindly put it was 15. 2015 it was issued.
She is now 55. So 15 means 11 years. So when she was 44 years, she was receiving ration.
She was, my lord. She has
She continued to receive ration till
2016, just for 1 year. She has received ration.
So then for the last 10 years, she has not approached authority.
My lords, may kindly see Annexure 2 at page 11. After our ration card was declined by the FPS, we approached the concerned authority and we wrote a application for the same. That was rejected, saying that we have more than 3 rooms in a house, my lord.
When it was rejected?
That was in 2016. 16/11
No, has she not constructed a separate house?
Living currently in the
So usually what happening for this kind of this fair price shop or rations, every big household has a separate house. When there is enumeration, they go there.
No, my lord, that is the case here.
It was written by, a officer. She, in fact, I remember her. She is a daring officer. She wrote everywhere in Jajpur district. Everyone is having a separate house. Everyone.
No, my lord,
so she has a fact, because you must understand, in case of a factual inquiry, if she doesn't have a house to show, because they do that with impunity.
My lord,
everywhere there will be a Pakka house, 2-storied, and there will be a side house, where they stay for receiving benefits.
No, my lord.
So factually, how I will improve, or you will improve as in the argument?
My lord.
You have broken one wall.
No, the present petitioner lives in the ancestral house. It's a joint family. However,
so how does
along with her,
how does it help? I choose to stay in one of the rooms in my mansion, of my father's mansion.
My lord,
in fact, it so happened. It's a coincidence. My mother as a student stayed there in one room. That whatever mansion, giving you to make you understand what the context.
My lord, I
So
have
she
one.
choosing to stay in a mansion or in one room or veranda. What the authority, because you must understand that this person who is enumerating,
The
or
authority
the fair price, if you don't listen, then you can't understand.
My lord.
Where I have completed. If you have understood, then please feel to tell me the answer. Then what is my question and what is the answer?
My lord is asking whether she is living in a separate house or she is living in a.
That was the kind of what you call. I had at the cost of you. I tried to. You see, that's the reality of life. I tried to make you understand. Just because you are innocently arguing this, that's another part. I'm not saying that's over now. It's a matter of in a lighter vein. I said that everyone is having a separate house for claiming benefits, which usually gets destroyed in flood or cyclone, because a multi-storied concrete building will never be destroyed. So for claiming this, they are having a particular house. In your case, what has happened? So that part is over now. Please don't get preoccupied with that. This lady stays in a particular room in her house, ancestral house. She says that though it is more than 3-storied, I stay in one room. So it's a case of physical inquiry. Fact finding.
It is not.
Then listen further. I'm not asking you. Please, first you understand, then you formulate. That is how you develop legal argument. How it's different from a common sense argument we are just discussing. It's not, it has some significance. When you are challenging this, you have to say that factually the finding of 3 rooms is incorrect. Or you can say that this is not a relevant constitution. You must have read the administrative law. Which book?
No, my lord, that was
You must.
Was it published?
For practicing in this branch, in High Court especially 226, you must read administrative law. So as a lawyer, your first challenge should be that it is not a relevant consideration. Then suppose you think that it's a relevant consideration because because it is not there in the guideline. And if you are not disputing the guideline prescribing 3 rooms to be the criteria for granting somebody else. So this has evolved. Earlier, everyone was getting fair price commodity. Everyone, irrespective of their government servants were getting. It is as per the criteria actually. Household member fair price. Now they have modified it. They say that if you have a 3-room house, or you are a taxpayer, you are a government servant, or you are having Group C, or whatever criteria. So in your case, are you challenging that this 3-room criteria is not correct?
No, my lords, I am challenging that in Annexure 2, they have only written in my specific letter, they have said that I have 3 rooms and they've rejected it. Later, when I have been applying for the past 10 years, it says that my phone number has already been registered and I need to try it with another phone number. But I live in one hand, I do not have a storied house, my lord. It is one.
You must understand that. How they will overcome it is their job will be at stake.
No, my lord,
A person
given a reason
giving the finding that unless you dispute that, so you have to bring the material on record what you have done. So that is how I asked you that after you were not provided with the ration card in way back in 2011.
It's 2016.
Sorry.
2016, it was rejected.
Yes, we have 2015 to 16 you had.
We had for 1 year.
16 for the last 10 years you are not having.
We did not have.
You applied in 2016. Again 10 years.
Again 10 years.
So now what is your stand before the authority regarding the rooms? What you have stated for that so that this court can entertain and adjudicate. You must understand. This is not a litigation by invitation. That since you have come, I'll invite them. First, you have to tell the court that I have stated before the authority for re-inquiry, I don't have 3 rooms. I do not have rooms, 2 rooms, whatever. That is how I am telling you that have you broken the wall?
My lord, we have repeatedly applied for ration card.
No, it's not a question of application without inquiry. By application, the statute or the scheme does not confer you any right for getting it.
But then
the authority satisfying itself regarding the facts.
There has been no inquiry to that effect as well, my lord.
That you have stated so that in the application, not the read petition. Because after you read all this law, while drafting, you will say, but you have to show factually that you have stated before the authority that there is no inquiry. Or I am not staying in. Basically, even no inquiry also, suppose you have not said that I do not stay there at my room, I do not stay in a 3-roomed house, whatever. Where is that?
My lord, to that effect, I have not annexed any
then that's the problem. How can this court issue notice? This is wastage of your time, court's valuable time. The person who comes to you and engages you, she is not bothered about her rights. You can't evolve it. You can't develop it. She has a problem with ration card. The other problem is that she is having 3-roomed house. She doesn't know. She doesn't tell you. She has to at least tell on oath before this court that I do not have a 3-roomed house. Otherwise, this person will lose his job. The fair price shop Delhi, you will be seeing fair price shops irregularity. Delhi, they are being suspended and they are approaching court. And for this lady, whoever is having 3-roomed house, if the fair price shop owner provides him, and then he's gone. You must understand that it's not a case of isolated right of individual. It is right of individual qua a scheme. Is gone to any fair price shop to receive this. That was practice of all at my age. But things have changed. After some years, he must have seen everyone was provided fair price. Quality may not accept, but at least kerosene oil was provided, everyone was accepting because it is utilized for fuel and lighting purposes. So those days are gone. It's a qualified right.
May I submit, my lord? As per statute, at the section 10, he has to lodge a grievance before the district grievance redressal officer, my lord.
1611, he has done it. She has done it. The person who has rejected, she has approached the authority. But the problem is,
close the rejection.
Nothing there, no material is there.
No rejection, my lord. They've just written it on page 11.
Rejection signature bond kar dele.
Yes.
The case is that after 1 year, on 2015 started, 16 stopped.
No.
But it doesn't require a rejection. That so it is stopped. It is not being. I mean, she is not receiving. That is the case, or whatever you can call it. She is not allowed to receive or stop from receiving. That's. But now the issue is that apanakara. Can you read Odia? Read page 11. Nothing. दुख परितापर विषय आम दिनहीन गरीब चाषी परिवार अटू देशर जीवन आम रिटेलर श्री जामिनी जंत्र जामिनीकांत चंद कहले तुम रेशन एमास इश्यू होई नाही तो दैट मच आपन सेति कहले ता बियॉन्ड दैट आपन किछि लेखलेन नाउ दिस कोर्ट हाउ दिस कोर्ट कैन इवॉल्व टू इनटू ए बिगर इश्यू आपन से फर्स्ट यू गो टू दैट अथॉरिटी सपोज टेल द एंटायर थिंग दैट यू डू नॉट हैव 3. What are your entitlement under the scheme? Modified PDS scheme. Now the question is that why modified PDS scheme is implemented? Is it discriminatory? On the face of it, it may be discriminatory. Everyone was getting, now all are not getting. But the thing is that it's a freebie. It comes with a cost. Preserving rice, wheat, paddy, rice and wheat and other dal and everything comes with a cost which is paid by the taxpayer. So it is being preserved, it is being transported, it is being distributed free. But dal cost is 100 rupees, rice cost is now 50 rupees. So that is how they have, it's kind of a, I mean, unequals being treated unequally. If you have 3-roomed house, you please purchase the market. If you are entitled, at least you should assert that before the authority. You want adjournment or disposal today? That much I can do. I grant time, so.
My lord, may then dispose it off with that direction that I'll approach the district revenue.
No, you take instruction. I don't know whether your senior will be happy or.
I'll take instruction.
Take a short adjournment.
My lord, a week later.
Mr. For the petitioner, likely. The petitioner is before this court. Kindly take your seat. I'll dictate the order. Take some time. Let me, Mr. P.K. Mahanti, AAC for the opposite party. The petitioner is before this court challenging the denial of fair price commodity as well as the into single quote ration card under the National Food Security Act, 2013. Trade with State Food Security Scheme. It is stated in the petition that the petitioner and her issued ration card bearing number देखी लिखी परिवे para 3B on 26/10/2015 family members सुनते कि family लिखले the members by comma, family of eight persons. This Bogorai Brock, Malasur, where issued. Thereafter, in the year 2016, the petitioner was informed in November 2016 that informed by the fair price shop dealer that she and her family are not entitled to receive the fair price of commodity. The petitioner has approached this court after 10 years. So upon being asked, it is submitted by the learned counsel for the petitioner that submitted by the learned counsel for the petitioner that the petitioner had approached the block development officer Bhugurai by representation dated 16/11/2016. So the learned counsel for the petitioner was heard at length. It is submitted that the petitioners, the purported ground of stoppage of commodity to the petitioner and her family is that they live in a house which has 3 rooms or more than 3 rooms?
3 rooms. 3
Which has 3 rooms.
3 pakka rooms with pakka roof.
They live in a pakka house for them. PUCCA, pakka house. 3 rooms. 3 rooms. It is submitted that the said fact indicated by the authority is not correct. As the petitioner lives in one room of a paternal house, of joint family property. Joint family property. Then Ms. Misra, it is unworkable. How this now 8 people will stay in one room?
No.
You must understand, you have to ask these questions, and that when you present something factually to a court, at least it should be believable, and that too after 10 years. But anyway, only. Property. So, the C6 and has adjournment to obtain further instructions in the matter. List in the week commencing. 30 दिन. 30 दिन ना आगुर चाहूँ के बे. 30 दिन. 30 दिन कोड़िए 26. Yes, next please.
Item 12.
Mr. Ajit Kumar Rai for the petitioner.
Yes, may it be loss.
Here amnesty, Mr. Roy.
Amnesty? No, I am not approached for amnesty.
They have issued amnesty notices in several matters.
Not,
But not in this case, madam.
Correct. No, Mr. Roy, that is how he says that. Mr. Then can it be Mr. Ray?
My lord.
Mr. This is now Ray versus Ray. So what do you say, sir? Amnesty?
My learned friend wanted to clear up the dues with installment. I have to take instruction. My lord may keep this matter to Monday.
That's a fair enough proposal. And if you, in the spirit of the amnesty scheme also, you can give him a little kind of breathing or little discount to that extent. Of course, not the statutory dues, whatever is there. That will help in the,
Petitioner can talk with the authorities. In that case, petitioner to talk with the authority.
Okay. So you accept notice?
My lord.
already filed.
One set, further one.
Further, I will submit.
Mr. Ajit Kumar Roy for the petitioner. You kindly take your seat, I'll dictate that.
My lord.
Mr. Roy, you'll approach the authority.
I've already on several occasions.
Okay.
And I also deposited 59 lakhs by this time and 13 lakh 61,410 they have collected from banks.
No, if that is not part of the affidavit, you serve it with
No,
the
it's part of affidavit, sir, my lord.
part of the affidavit.
Page and thus. Yes, paragraph 90, running page 12.
So, I mean, I want the breakup of the duty and how much you have paid.
Backlog of the due, as per the notices, is coming 1 crore 33 lakhs. Your lordship may kindly pass over a copy of the just.
So, because he has to understand actually.
Yes, sir.
ଆପଣ କଣ କହୁଛନ୍ତି ସେ ବୁଝିବା ଦରକାର.
They're giving different notices. They have challenged, they have charged interest, damages, total is 1 crore.
12 ଲକ୍ଷ ପରେ 60 ଲକ୍ଷ ଆପଣ ଆହୁରି ଦେବାକୁ ଅଛି.
ହଁ, as per 60 lakh 45,552. Business is stopped.
Statutory dues, no. Statutory dues is a very serious thing. Otherwise, if the garnishee order would not have been passed, you would have never paid.
No.
And this is you are employing personnel.
A personal 2,000 employees at different sites.
You are employing personnel and not implying this. This is a fundamental statute.
Yes, sir.
For welfare statute. For welfare of the workmen.
I totally oblige.
So anyway, since you are paying it, so you'll be paying it.
Yes, ma'am.
My lord, as per Annexure 4, all the payments are in up to the year 2025, and a garnishee order issued in 2026, my lord. Execution order.
The garnishee order must flow from the demand notice, na? Demand notice they have given.
Up to date position reflected as 1 crore 36 lakh and something.
As for my chart, it is coming 1 crore 33 lakh 06962.
Page 39.
My account bank balance.
Correct. You upon page 30 ku jaantu.
Page 30.
Oh.
Petition, madam.
Correct. जो अकाउंट गुड़ाक आपन गार्निशी ऑर्डर गुड़ाक हेची बैंक को डायरेक्शन अछि गार्निशी और एक्सिस बैंक रे अछि
एक्सिस बैंक
सो गार्निशी ऑर्डर हेले कोन होची कॉन्सिक्वेंस कोन होची व्हाट इज द कॉन्सिक्वेंस ऑफ ए गार्निशी ऑर्डर
they will not allow me to operate the account.
Correct.
Yes, my lord.
So now what is the amount due and what is the amount kept in the amount parked in those accounts?
That I have taken instruction that take because they have taken whatever amount they have.
If you do not, if you engage people and do not pay the ESI, all
no, ESI I have already paid, my lord. Up to 2021.
Sir, if you pay, sir, never ask you.
No, my lord.
This is a kind of a beneficial scheme which they are operating.
There, my lord, that's why legislature have already given a power on them under section 45F. They can also grant payments.
No. Sir, that's the point, sir. You are not coming up. Apano kete installment re kebe debe. Apano right now you will talk to them. That's it. But if you want an interim, I am thinking about the interim order. I cannot grant you an interim order right now. I cannot allow you to operate those accounts because that is the sole. I mean, they are the
whatever condition your lordship will put, I will comply it.
No, you obtain instruction. How much money?
I will pass that order on Monday. I can take instruction by
That will be better.
Mild.
Because I think you are senior Mr. Roy is tentative. He doesn't have very clear instruction how much he will deposit when.
Petitioner also employed some employee with us also.
Yes.
My lord, interestingly, garnishing order has been issued to the regional director ESI.
That is how he has become confident.
They have not.
The person working under you, the ESI dues are not paid.
Mild. And recovery officer should notice.
He might be employing his persons in railways, other government offices, everywhere.
There is a 2,000 or more.
But Mr. Ray, actually, here this closing down, as I said once earlier also,
My lord.
Closing down these kind of organizations also impacts the common man.
Yes,
2008.
Yes.
This I said in another matter. Mr. Somnath Mishra was arguing. So that was it. In fact, but it was a amnesty scheme already there.
Yes.
And recovery officer already issued garnish against the head of the department also, of our department.
It's a classic case.
Classic case.
Yes. Ajit Kumar, petitioner. Sir, your full name now, because I have to write it correctly because then.
Amarendra Prasad Rai.
RAY.
My lord.
Sir, Ochante Amarendra. A likhioni, pura na likhiya pade. Ajit Kumar ROY. Tole likhibe Amarendra Prasad Rai. The petitioner, you are a partnership firm or, or a limited liability partnership firm.
Partnership.
Petitioner partnership firm providing manpower services to various organizations. Employs about 2,000 persons as stated. Kindly take your sheet. I'll dictate some time. I'll take required.
Yes.
Yes. As stated. The petitioner is before this court challenging the garnishee order dated 18/2/2026 18.2.2026 and attachment notice dated 12.02.2026 passed by the number 1 recovery officer, Employee State Insurance Corporation, Panchadip Bhavan, Bhubaneswar. Mr. Amarendra Prasad Ray has been solved, who usually appears for the, sir, you are standing counsel.
My lord.
The standing counsel for the opposite parties. Upon advance copy, sir, appears and waives notice for on behalf of OP number 1 and 2. Let one more extra copy be served on the learned counsel for the learned standing counsel for the opposite party. It is submitted by Mr. Roy, learned counsel appearing for the petitioner, that the petitioner has been trying to comply with the demand of opposite party authority, and he has already paid a substantial sum, that is rupees 49. Siti, on chess.
But on site. 5.
Side 9. Apono kintu page 9 on chess.
Page re mo पढ़देइथिलि भूल ले देखिली जो annexure 4 रे मेरे दलाल को 59 आसुछि.
नहीं अपन अगर पारा 14 ने 59 लिखते हैं.
Wrongly,
14 ने
inadvertently I omitted.
Already deposited of rupees 59,00.
Yes, ma'am.
0,000.
Yes, ma'am.
Through drafts on various states stuff. They submitted that due to operation of the garnishee orders and the garnishee order as well as the seizure order. Consider key order. Attachment notice and the attachment notice.
Yes.
The petitioner finds it difficult to operate his accounts and payment to the daily wage, payment of daily wages, monthly wages, public monthly wages, is personnel employed by him. He submits that he will approach the authority for granting a suitable installment for payment of the area dues. In response, the learned standing counsel submits that Mr. Roy submits that he shall obtain instruction by the next date. The matter shall be commencing AC.
सोमवार आसू
In the week commencing 16 आसू. In the week commencing 16/3/26.
16/3/26.
Okay?
16/3.
16/3/26.
I guess.
16th March 2026. ଆପଣ ଓକିଲତନାମା କେବେ ଫାଇଲ କରିବେ? ଓକିଲତନାମା duly execute
within a week.
By the learned standing counsel, Mr. Ray shall be filed within 5 working days. Within 7 working days.
My lord.
Yes.
My lord,
Name of Mr. Ray shall be reflected in the cause list as well as the case brief upon filing of the Okilatnama.
My lord, one sentence, 13,61,410, they have already collected from bank.
What a line would like you add karibe, he has paid and rupees kete
13,61,000.
Comma 410 has already been collected from
SBI,
from State Bank of India.
Indian.
Bosajnagar.
Jotton, you know.
Sir, apart from 59.
Apart from 51 lakh crores.
Apart from it is extra sentence added.
Sir.
Has already been called from a State Bank of India Jotani. So the submission is yes.
So interim.
No coercive action na kono?
No
further coercive action.
Yes.
But garnish order is not being lifted. I cannot do that because otherwise you will run away. How this court will enforce the amount?
I'm already filed.
No further coercive action shall be taken against the petitioner till the next date of
yes. Publication.
Yes, please.
Administration.
Sir, ଆପଣ ହିସାବଟା ଫେରେଇ ଦିଅନ୍ତୁ ନା ନା ସେଟା ମୁଁ ରଖେ.
My lord is yielding also amnesty scheme.
Acha. Yes. In fact, that is the query of the courts. Hisabta deyi diyo. In several cases, it is seen that the authorities have promulgated amnesty and notified the same to the individual. ତେଣୁ ଆସିସି କହୁଛନ୍ତି ନା କଣ? ଆପଣ ଯୋଉଟାକୁ ଆପଣଙ୍କର ଯୋଉମାନଙ୍କୁ ଦଉଛନ୍ତି ଏଟା ନୋଟିସ କଣ ସେମାନେ ଆସିସି ନା କଣ ଦେ ଆର ନୋଟିସ କଣ ଲେଖି individual to various employers who are covered by the ESA Act. So, the learned standing counsel shall also obtain instructions regarding the said scheme.
My lord. तार गोटे प्रॉब्लम होती कोन जो केस गुडा को 31st 2025 सुधा
आपण कहउथिले तर once you
तेनो एथरे देले भी किछि हबो.
Let us see. It is better that you should work out solutions.
My lord, bank attachment will not be lifted.
No, not today. Let us see ଆପଣଙ୍କର କେତେ capacity ଅଛି ଦବା ପାଇଁ. In most of the cases, what is found, Mr. Roy, is that
my lord,
total amount 5 lakh thiba demand thiba 20 lakh. So what is the point in lifting also?
My lord, there is
so there can be order that apart from that amount you can operate.
Yes.
So upon যদি কোন furnish করিবে banking furnish করিবে, how you will secure that amount? Approaching the court will not alleviate your that problem.
No, I am not.
You have to be patient with this authority.
Already
they have acted in accordance with law.
I have already filed representation for installments.
Yes. That. Very good. Yes. MS Sujata Jena, senior advocate, along with MS Sonali Ponda for the petitioner.
Madam, I have a short prayer
Yes, please.
for a direction to the Judge Family Court to take up the CP, which is filed under Section 9 of the Hindu Marriage Act, instead of proceeding with the divorce
So it has to be taken up together.
together.
So have you made that prayer before the court? And what is the order passed?
No, only I have prayed before the court that may be taken up since it is filed for restitution of the conjugal right.
So why is that application before the court? Which page?
Application, no, oral submission.
So that cannot be done. So you can very well make that prayer. Either you after making prayer, the order is passed, you can amend this, or you can withdraw this and file it again, because it's not res judicata. This can't be a res judicata.
Yes. Your Lordship may, with that observation, your Lordship may dispose it of.
Okay. Her learned senior advocate for the, and congratulations. This is we are addressing after so many years.
This my
At least
pleasure.
this is a transformation.
My pleasure.
Starting in with 1999 and now in 2026.
ଆପଣ 1999 ରେ ଜଏନ୍ କରିଥିଲେ?
Yes, yes.
ହଁ.
Like senior advocate on behalf of the petitioner, it is submitted that the petitioner has prayed for taking off of the petitioner wife was it?
नहीं,
The petitioner husband. The petitioner husband has prayed in this petition was for a direction to the learned judge family court -2 Bhubaneswar for taking up of the CP upon con number
CP number
904.
904.
904.
ଗୋଟେ minute.
କୋଉଟା କଣ ଭୁଲେ ମୁଁ ବୋଧେ ଆଉ
ହଁ 904. CP number 90 because it has been numbered renumbered twice. So 904 is the present number after being
CP number 904.
Yes, of 2025.
2025, which has been stated to have been filed under Section 9.
Yes.
Under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Stop. It is further stated that C number kete 13 ta
13 টা হচ্ছে 672 of 24.
CP number 672 of 2024 is already pending before the learned judge family court. 2 dash 2 Bhubaneswar para. It is stop. On being asked, it is fairly submitted by the learned senior advocate that the petitioner has not moved the court, the learned court in season of the matter. That is learned judge making any such prayer, and he shall move the said court. Okay, stop. Accordingly, the writ application is disposed of. The petitioner shall move the appropriate the court in season of the matter, seeking appropriate prayer by making application, which shall be considered on its own merit in accordance with law.
It has been fixed to 9th on that day because if you proceed further in the divorce proceeding, it will be infructuous. The very purpose of filing will be infructuous.
Proceed further in the sense you have to yourself participate, so there's no difficulty. It is submitted that the application shall be made before the learned court and no March.
Yes.
तो आज ही तवर चढ़ा आज ही कितनी होगी आज I'm so sorry आज 5 तारीख को मोर भी on 9 March 2026 and therefore the application shall be filed by
on that day if it is filed by
7 सुधा फाइल करना by 7 March 2026 stop. Upon filing of the application, the learned court shall consider the same in accordance with law.
On that
সেটা কইবনি because সেতরে আপনকৰ you have to be the other side has to be noticed. There are so many things.
ସେ ଅଛନ୍ତି ତ
Then let us see because that can be predicted now.
That is true.
Yes.
Oblex.
Yes.
My lord, copy
It
of
is
your
further
lordship.
clarified that this court has not expressed any opinion regarding the merits of the petition, the merits of the contentions of the petition
Right.
of the petitioner or the opposite party before the learned judge family court.
Urgent copy of your lordship.
Urgent copy of the order. তারপরে এটা আজ লিখিবে তারপরে appearance লিখিলে সেটা লিখিবে the appearance memo of the learned senior advocate shall be taken on record.
Oblex.
The rest of the matter after recess. Anyone seeking adjournment can take it later.
Present before this court, my lord.
So whether he is present or he is not present, that's not matter. So you ask him, he will go to the he will go to the oath commissioner, give his detailed affidavit.
My lord, affidavit was already prepared, but the documents was not matched.
He will give his present whereabouts, file that affidavit, and if it is not matching his present just 1 second. It is there.
My lord, in details,
You have to listen to understand.
my lord.
If he is trying to fool you, it is at his risk. So he is, what is his name? Sudhir Ranjan Das.
My lord.
What is his address? Whether given is correct, he has to. You just look at this is 2022 application.
My lord.
So just look at verification. So he has not disclosed his present place of residence, and he has not told his lawyer the correct where he is employed, who is his employer, and he has stated to be employed in army or some kind of his navy or something somewhere.
My lord, he was at the
Whatever. So where does his pension account and all those details? He has to file the affidavit today just now, or I will detain him. He'll be state guest, entertained by Mr. Sahoo or Mr. Mahanti. So enough of this method, because you must. It is really surprising that they are able to take the lawyer for a ride also.
My lord, I have given the present detail address.
Sir, you give up, sir, after, but that is prior to court's direction. Today he will be directed to file affidavit supporting his, he give his present address, his present employment, his present place of residence, and details of his income details, or it will be probed further.
One week time or Monday.
No, sir. Either he knows it or he doesn't know it. Because Monday will not end up, he becomes a kind of a god to know everything. To knows about himself. I'll record that for disclosing that also he wants time till Monday. But you file that affidavit today.
My lord, I will file, but the bank details and the present income.
Whatever he knows, whatever where he was employed, what was his avocation, what he is doing now, where he stays. Yes, Mr.
Yes, my lord, last appeal directed, so that's why he always present. I am also doubt in which department is nothing not there. Okay, correctly that address is not there. However, I have intimated from which department that is the problem.
Okay. No, I am appearing for the respondent. What is your name, Mr. Sahoo? Your full name is?
Akshay Kumar Sahoo.
Mr. Akshay Kumar Sahoo. Okay. Appearance likhibe CCR Panigrahi for the petitioner. Mr. Satya Prakash Satpathy for the. Why he is standing there?
He is the petitioner.
He is not required to stand inside the court. No, nobody requires his. Ask him to sit.
Malaram. He was directed to present, remain present. For that reason, has come to the court.
No.
No.
You must actually, his lawyer was not sure about his, he could not have.
No.
You have not read the order, that's the problem.
Today morning, yes, okay.
So Satyaprakash Sapathy. By order dated 18/2/2026, after hearing the learned counsel for the petitioner at length and Mr. Sisira Panigrai, learned counsel for the opposite party, the following order was passed. Stop. When the matter is taken today, as directed at paragraph 11 of the said order dated 18/2/2026, Mr. A.K. Mahanti, Senior Panel Counsel. Senior Panel Counsel is present on behalf of the learned DSGI, Union of India. It is submitted by Mr. Mahanti that pursuant to the, as directed by order dated, as directed at paragraph 11 of the order dated today 26. He is trying to verify and obtain the details of the petitioner. You ask him whether he will deposit or he will be arrested.
Well, he is ready to deposit.
So his readiness, he is ready since when? From today he is ready.
In between the
7/12/2018. Now 7 years. 7 years. So
he was already paid a sum of rupees 2,10,200 in the account of the opposite party.
When he is paid, just now we give the details. The payment
for that is in the bank.
Sir, don't believe them. You are making a statement on behalf of a petitioner, stating in so many words that he has deposited. When the court asks you, you say that I don't have the details. I have to record that, Mr. Sahoo.
Bank details.
These kind of unscrupulous persons.
No, in fact, the bank.
You must understand what is being asked to you. Then you start submitting. Who has told you that he has deposited this amount? The amount is exactly 1,000. So how does he know that?
From the bank details.
From the bank. So from that bank details, he has to show you on which date it has been paid.
For that reason, I
no reason.
Today the petitioner is ready to deposit.
Mr. Sahoo, you have to understand the question. Or I'll dictate, then you listen, then you answer. Your lack of comprehension or your client's lack of comprehension doesn't help me. I have to pass a reasoned order. When you are saying that I have deposited 2,31,000 as per my bank details, you are not disclosing the dates.
I have already received the document, but
you give dates.
For that reason,
you must understand that your bank is not an alien bank. It's a normal bank where you operate.
State Bank of India.
Exactly. So the date itself is there. But the date.
I will pay.
I can advise pass it over or I will detain him. I have no choice. For 17 years, he can't. Today, Mr. Sahoo, either he is giving the details of payment, he is detained.
May I pray one
thing? Please don't pray anything. You see, changing of counsel, not reading the order doesn't imply. I have the advantage of not reading the order.
No, my lord.
I cannot say the tenor and vigor of my order.
My lord, today the petitioner is ready to pay something.
Not something.
My lord, one
lakh has to be deposited before this court. Either he is doing it or he is detained.
1,50,000.
No bargaining here. No bargaining here.
My lord,
first of all, he has to disclose the details. Or they are investigating, or the court will find out.
Your lordship,
second, 2,13,000 I'll just now record, and the details you have to give me. With the court, not me, nothing to do.
Only 2 days only.
I have 2 days, sir. Once you disclose the amount, you have to give the details. I cannot make that. I cannot pass a follow order.
No, my lord.
That I believe you.
My lord, in the bank details, my lord, all the documents is available with me, but there is some.
Sir, 2,13,000, as you have said, you have to disclose the details of the deposit. You are so specific about 2,13,000.
My lord,
give it.
And
I'm passing it over. You sit down. I'm passing it over. You give the details.
Before
you call that the police wala let him remain present.
Before rising, my lord.
No, not before rising. 2,13,000, how you have informed? Because you have stated that you have to state and it will be, you will file that affidavit. Maybe after, but today when you are making a statement before the court, after the last, it has to be. Duty to CEO. You must understand you are making it is aspersion on the court. What you cannot read from the paper, I will find out.
No, my lord.
It is your duty to find out from that when it was paid that much.
On different occasions, he was.
Sir, whatever occasion, sir. Whatever occasion that's not being asked.
He is trying to prepare and tell the details.
Details. How much time will it take Mr. Mohanty to verify?
The department, the letter is issued, but I'm not sure.
At this stage, Mr. Akshay Kumar Sahoo, Learned Counsel, submits that the petitioner has obtained change.
With me, madam.
Cannot be. I cannot record that. Has obtained change. So do Kalatnam. By engaging Sri Sahoo, when he was executed in your favor?
Today.
Aji. By engaging Mr. Sahoo, today that is now Aji kete 5 tarikh, 5/15. The earlier counsel, Mr. Sisir Panigrahi, seems to have given endorsement on the said Wakalatnama on 1/3/2026. Wakalatnama is dated 5/3/2026. The said Wakalatnama shall be filed in the registry, shall be scanned copy be updated. Can be updated and तब कौन सी बात छड़ाई थी लाइक मैसेज ଆପଣଙ୍କର ଏଠି ଯୋଉ ଲୋକମାନଙ୍କୁ ପଠେଇବା ପାଇଁ ହେଲେ ତାକୁ ଡାକି ଆଣ ଏଠି ଅଛି The reasons for change of the counsel cannot be deciphered or be guessed. However, change of counsel would not come in the way of giving effect to the order dated 18/2/2026. The petitioner on the Learned Counsel, Mr. A.K. Sahoo Learned Counsel submits that the petitioner has deposited amount of rupees 2,31,000 to the account of the
PhonePe
opposite party wife by various means, including PhonePe da co category. PhonePe is UPI, including UPI bracket PhonePe. Since the amount is very specifically stated to be 2,31,000, the matter is passed over. As it is informed to the court by the Learned Counsel, Mr. Sahoo, that the petitioner is present in person. The matter will be taken up at 3 p.m. to enable the petitioner to give the details of the payment of 2,31,000 as instructed to the Learned Counsel, Mr. Sahoo. The petitioner shall file affidavit today sworn before the oath commissioner of the court, giving the details of his present address, including the details of his past and present employment, the details of his accounts, and the details of his retirement benefits, salary benefits, and other benefits that has been received. It is stated as it is stated by the Learned Counsel that for the petitioner that the petitioner uses mobile banking for making payments. He can get this detail from the details from his own mobile phone. Though Okultnama is not on record, since it has already been executed, the Learned Counsel, Mr. A.K. Sahoo, is stated to be representing the petitioner today. Name of Mr. Sahoo shall be indicated in the cause list as well as the case slip appearing for the petitioner from the next list. ତିନିଟା ଆଉଥରେ ନେବେ ହେଲା ତାହେଲେ ଆଉ କାହାକୁ ଯଦି କହିବେ ତାହେଲେ ମନେ ପକେଇବେ ଏଇଟା ଅଛି matter shall be taken up at
330
no 330
affidavit
because I have to make arrangements. My staff is not aware. He is thinking that he will collect it from him jail and produce here. I have to make arrangements.
affidavit
He must understand that there are provisions in law. This is nothing.
ନାଇଁ typist
ସେଇଟା ତ ଆପଣ ଚାରିଟା କଥା ହାତରେ ଲେଖିକି ଦେବେ. The petitioner is permitted to give the details as directed, his own handwriting and swear the affidavit.
ତାପରେ ପୁଣି ୟୁଥ୍ କମିଶନର ଟିକେ ସାର୍
ୟୁଥ୍ କମିଶନର ଯେତେବେଳେ ଡାଇରେକ୍ସନ ଦେବେ ସେ ରାତି ଯାଏ ରହିବେ. ଆପଣ ବୁଝିବା ଦରକାର. ଆପଣ ଯେତେବେଳେ ଯାଇ କହିବେ ଯେ କୋର୍ଟ ଡାଇରେକ୍ସନ ଅଛି, କୋର୍ଟ ମାଷ୍ଟର କହିବେ ତ ସେ ଷ୍ଟେଟ୍ ଗେଷ୍ଟ ହେବେ ଯଦି ତାଙ୍କୁ ଫେରେ ଆରେଞ୍ଜମେଣ୍ଟ କରିବାକୁ ପଡିବ ନା ସେଟା ଫେରେ ଭାବିବା କଥା. ୟେସ୍ ଆପଣ ତିନିଟା ବେଳେ କଣ ଦେବେ କି କଣ ବୁଝିଲେ କହିଲେ
ତାର ଡିଟେଲ୍ସ ଆଡ୍ରେସଟା ଦେବେ ପ୍ରେଜେଣ୍ଟ ଆଡ୍ରେସ
ଏଇଟା ବୁଝିଲେ ଏଇଟା ଅର୍ଡର କୁ ଡାକିଲେ ଆପଣ ସାର୍ ଭେରି କ୍ଲିୟର 2,31,000 ଡିଟେଲ୍ସ ଦେବେ ତା ଆପଣ ପରେ ଫାଇଲ କରିବେ ଆପଣ 4:30 ବେଳେ ଫାଇଲ କରିବେ କେତେ ଫାଇଲ କରିବେ ଅପ୍ ଟୁ ୟୁ ମୁଁ କୋଉଠି 3ଟା ବେଳେ କହିଛି ଆଫିଡେଭିଟ୍ ଫାଇଲ କରିବା ପାଇଁ ଆପଣଙ୍କୁ ମୁଁ ବି ଆଜ୍ଞା ଏତେ ଫାଷ୍ଟ ନଥିଲି ଯଦିଓ ଫାଷ୍ଟ ରିଲେଟିଭଲି ଫାଷ୍ଟ ଏତେ ଫାଷ୍ଟ ନୁହଁ ଆପଣଙ୍କୁ ଯୋଉ ସେ 2,31,000 ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଛନ୍ତି ସେ କାହିଁକି ଆର କାଉନସିଲ କୁ ବାହାର କରିଦେଲେ ଚେଞ୍ଜ କରିଦେଲେ because difficult questions are asked and that is the reason many times I have seen our seniors they never accepted any brief on transfer.
No.
Because basically the person is not respecting a lawyer. The person he is not respecting him. I have seen. He thinks that he is an agent. He is an officer of this court, of today mine court. Whoever is the lawyer, he is officer of mine court. That is the situation. Is it? Suppose he doesn't want to disclose. Let him not disclose. Let him face the consequence. Yes. And let us see if it is a battle of wits. If at all it is a battle of wits, it's not a battle of wits. It's a factual thing, whether he has paid or not. If he can succeed like this, it is his choice. He may not be able to succeed like this. This is not the way to handle a court order. Yes, next.
Yes. Item 14.
I am appearing from the petitioner.
Yes, please.
Kindly to be taken up next week.
अरे डिफेक्ट रिमूव करना थी मैडम आपको नाम मैडम
Sabita Behra.
पावर नहीं on behalf of Mr. Naik. Miss Sabita Behra on behalf of S.K. Naik for the petitioner. The Learned Counsel for the petitioner seeks and has for the 7 days for the time to remove the defects as pointed by the SR within 7 working days.
Okay.
Mr. Mohanty, Mr. Farad, this copy has been served.
This one.
Copy has been served. You will file objection or?
You have already filed. Objection has already been filed. I had last order, my lord. It was ordered that issue regarding.
Standing counsel for the appellant. Mr. Mohammed Farad is for the respondent. Yes.
My order dated 9/1/2025. My lord.
Just a second. Since I was taking up the past matter, so yes.
Issue regarding condonation delay is beyond the statutory period, still sub judice before the Honorable Supreme Court.
Acha, see the question. Any development?
I have to inquire.
Mr. Paradis, Mr. Das.
There has already been development regarding 2013 Act.
Yes.
Supreme Court has already decided that case in favor of the land users that it can be extended after.
That
yes.
Recent decision.
Recent decision.
By Justice C.T. Ravi Kumar.
My lord. That is there. I can give the citation within minutes, my lord.
No, you have contributed, I have contributed, so it will now work out.
My lord, my lord.
No, I have read that. I think it is available. Big city, table, city Ravi Kumar. Seta then examine a copy. I'll provide you. My office will provide you. Mr. Paradis, Mr. Mahanti. You inform Mr. Mahanti, Haripad Mahanti also.
Another thing is the appeal has been preferred in land losers, and the neighboring
So if the Supreme Court has held that the delay, because now I recollect Mr. Das has helped, that it is very clear that all the appeals are there has to be the delay on that ground cannot be condoned. Delay may not be condoned on some other ground, but since there is a statutory bar, you will not condone the delay. That is not. But again, 2013 Act. So that way. So Supreme Court decision should occur. Can it be passed over? So let us see that. Can pass over. Next.
60.
May I please, Your Lordship?
Yes, please.
My Lord, your order dated 28/1/26, my Lord has asked us to demonstrate regarding the payment, interim maintenance pending.
Your name, sir? Apanagana?
Sanat Sushohan Panda.
So SS Panda for the petitioner. The Lord Counsel for the petitioner refers to the order dated 28/1/2026.
My Lord, we had filed an affidavit on the same light to demonstrate the payment.
Details have been given.
Yes, Your Lordship.
By in the it is particularly paragraph 3 to submit that the details of the payments केते टंका देइछन्ती टोटल केते टंका ड्यू किस लिखिलेनी
My Lord,
अरे सेटा कोन आपण why you are leaving it on the court to do those assistance?
My Lord, in paragraph number 3, I have mentioned
read it
that realization of area maintenance amount of rupees 2,07,000 for the period of 5/11/2019 to 5/6/5/2022 on 10/3/23 the petitioner deposited an amount of rupees 20,000. On 15/5/23 the petitioner deposited an amount of 10,000. On
so what is the question to you? That the court you will assist the court in reading, or the question is what is the question to you? That why you have not given the details of the amount due and amount already paid. So what is the total?
Total I have paid, my lord,
2,10,000. That the court knows. But you should have done that. It is not that I am to assist you. That is your job and duty. Out of the outstanding, you have paid 2,20,000.
Yes.
19/2 रे आपण ଦେଇଛନ୍ତି.
आगे
18 ऑर्डर केबे ହେଇଥିଲା कि?
ऑर्डर आगे 28/1.
अच्छा. से ହେଇଛି 1,80,000 आपण ଦେଇଛନ୍ତି तापर. ଆଉ 7,000 टंका आपण दउଛନ୍ତି.
Yes, ये कंटिन्यू पे.
सेटा केंति देखौଛନ୍ତି?
मतलब
आपण एते जो 2 पृष्ठ एफिडेविट कले न करी कि गोटे पारा लिखिथान्ते जे हम ଦେଇଛୁ that much. तापर 7,000 टंका केंति दउଛନ୍ତି लिखिथान्ते दुईटा पैराग्राफ. वन लाख 80 टा आपण केमती डिपोजिट कले डायरेक्टली तांगा अकाउंट रे ना कोठी डिपोजिट करछन
डिमांड ड्राफ्ट
ना एग्जीक्यूटिंग कोर्ट रे करछन
एक डिमांड ड्राफ्ट हैज बीन गिवन टू
अरे डिमांड ड्राफ्ट कले कोठी कले
इन नेम ऑफ द ऑपोजिट पार्टी
की कोना कला एनी ड्राफ्ट हैज टू बी समबडीज नेम कोठी डिपोजिट कले
इन नेम ऑफ गीतांजलि दास.
Deposit where the draft has been kept. Have you retained it yourself? Have you deposited in the court? Have you handed it over to somebody? That is the question, sir. You understand what is a demand draft?
Yes, sir.
कौन लिखा है demand draft?
To whom it need to be?
No, on demand pay so and so. You have read the Negotiable Instruments Act. So where is that draft? Where it has been kept? Who has received it? That I want. You have not disclosed. Sir, you are creating more questions than answering the simple point question asked to you, sir. You take instruction and file proper affidavit. Where you have stated, where is the draft? By preparing a draft, who receives the money?
The bank, I make payment in the bank and draft is given on demand that shall be handed over to the person.
So the draft is an instrument, negotiable instrument. You have to hand it over to the executing court. You can hand it over to the person who is holding the decree, or you can retain it yourself. So where is that?
On that light, it is not clear.
So it seems it is very dark. So how I can enlighten you? I have tried my best to explain you. Have been filed. Details of the payments made up to 23rd February 2026 have been filed in the form of an additional affidavit on behalf of the petitioner, sworn to by the petitioner himself. Sworn to by the petitioner himself. Stop. The affidavit is available on record, marked at flag D. Paragraph 3 of the affidavit indicates thus. On being asked, after preparation of the demand draft of rupees 1,80,000,000, vide demand draft number dash dated 19/2/2026, drawn on UCO Bank, Jagatsinghpur, which is after the order dated 28/1/2026. What has happened to the draft? Whether it has been deposited before the executing court or handed over to the opposite party, or the same is in whose custody? The learned counsel for the petitioner has no answer. Stop. He seeks adjournment. Kebe asparibo? Kali asibo?
Next week. Any day next week.
List in the week commencing. List for orders in the week commencing. 9/3 परंतु 9/3/2026. ତାପରେ ଆପଣଙ୍କର ଆଉ ଗୋଟେ ଜିନିଷ କୋଉଟା ଜଣା ପଡୁନି ସେଥିରେ, ଆପଣ 7,000 କୋଉଠି ଦଉଛନ୍ତି ସେଟା ଲେଖିଲେନି। ରେଗୁଲାରଲି ଇନ୍ ଦ ଆଫରସେଟ୍ ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ତ ଲେଖିବେ ନା, କେସ୍ ନମ୍ବର ଏତେ ବିଫୋର ସୋ ଆଣ୍ଡ ସୋ କୋର୍ଟ। ଆପଣ ଯୋଉ ଅର୍ଡର ସିଟ୍ ଟା ଦେଇଛନ୍ତି ସେ ଅର୍ଡର ସିଟ୍ ରେ ସବୁଦିନର ଅପ ଟୁ ଡେଟ୍ ଅଛି, ତ ଆପଣ ସେତିକି ତ ଷ୍ଟେଟମେଣ୍ଟ କରିବେ। ଦ୍ୟାଟ ଇଜ ୟୁର ଜବ ସାର୍। ଅଦରୱାଇଜ ୟୁର କ୍ଲାଏଣ୍ଟସ୍ ୱିଲ୍ ନଟ୍ ଟେକ୍ ୟୁ ସିରିୟସଲି। They treat you as if you are their agent. I mean, you are the spokesperson in that sense. Se jaha kahbe to apan seta kahibe ni. You have to say something legally nuanced. Most likely 7,000 ଦଉଥିବେ and ଯେହେତୁ ବାକି ଥିଲା ସେଟା ଏବେ ଦେଇଦେଲେ court order ପରେ। And you have achieved something because you have persuaded him to deposit that. That will help him. Yes.
16.
16 ଗଲା ନା।
17.
मेंशन कले परा अपोजिट पार्टी जो थिले ना परा ऑब्जेक्ट कले आगे प्रेजेंट थिले आज दीटा मैटर अपोजिट पार्टी थिले सेटा को मैटर मिस्टर शर्मा का मैटर तो थिले स्टेट ठीक अछि ठीक अछि तो मत लागला 17 भी ऑब्जेक्शन थिला तो मु ताको अर्जन कर देबाटा बर्तमान तक ठीक अछि 17 पर अर्जन कर देबे वो वी कमेंटिंग 30 दिन तो करचंती हो
18
तो सूर्यकांत दास for the petitioner, Mr. Prabir Kumar Ray for the opposite party. Commuted value पाइगले?
Well, I have filed the detailed affidavit I filed.
So you serve a copy.
Copy served.
So you take it up. You will obtain instruction on that. Interestingly, Samima Faruqi that this is a knife found after we discussed.
Yes.
Para Mr. Ray, you see this?
Well.
Exactly the same point the Supreme Court has said. Exactly the same point. He has taken. Okay. Language, of course, we cannot, at least I cannot match it. Honorable the Justice, Chief Justice Deepak Mr. Denmark. Just see 2021. 21. The facts are somehow very similar.
Yes.
Sir, Ray को देखा था actually. Because आपन तो you will be happy to see that. Because he will be unhappy to see the Supreme Court's observations. 21. So I'm passing it over. Just both of them can go next. ठीक है 21 अपन तो तारीख देते रहते हैं तारीख पे तारीख यस अपन में adjournment चाहते हैं
21 my lord से affidavit last time my lord direction देते affidavit फाइल करिया भाई
yes
ऐसे affidavit फाइल करना चाहिए
है नहीं
the course of the day
Mr. R. Pradhan
MR Pradhan
Mr. MR Pradhan अपन को R. Pradhan नहीं जी Mr. MR Pradhan for the petitioner Mr. Palta Singh not a distracting counsel Mr. MR Pradhan not a distracting counsel petitioner Mr. J. Pradhan Mr. S. Palta Singh.
Will your lordship kindly take note of my presence?
Instructing counsel for the opposite party. Mr. Palta Singh, learned counsel, submits that affidavit. Order कितने थिला? Affidavit in terms of
22-1, your lordship. 22-1.
Mr. Saber Mishra, senior advocate, along with hybrid mode lecture. It is submitted by Mr. Palata Singh that the affidavit on behalf of the opposite party corporation shall be filed within 3 working days.
Yes,
so
my lord. Yes, my lord.
3 working days, copy shall be served on Mr. Barik, lauded counsel for the issuing counsel for the petitioner. List in the week commencing. It has to come for admission because there is no point in keeping it for orders. List for admission in the week commencing. 30/3/2026.
My lord, may I trace on? My lord, I have filed petition that is IA number 3057 of 2026. That may be allowed, my lord.
You serve it.
I have already solved. Copy already solved, my lord. Government and
on the government.
No, already solved, my lord. Already solved.
They have to say something. They have to obtain instruction.
My lord. Then
copy पाइचंदी. Any instruction on that?
No, my lord, instruction.
अपन लिखिए आइए 3057 of 2026.
My lord.
Yeah. The petition has been filed by the petitioner for seeking amendment of the
Amendment of the petition, my lord, writ petition.
the petition, amendment of the writ application as per the schedule mentioned.
My lord.
Copy of the application has been served on the Learned Distributing Counsel, Mr. Palata Singh, for the OP number. Mr. Mahanti, you are appearing here, or Mr. Sahoo? Who is appearing?
Mr. Sahoo.
Mr. PK Sahoo कर देवे. এটা कितना number item?
Item 21.
21. Mr. PK Sahoo SC. Mr. Sahoo for the OP number 13. And Mr. Palata Singh.
2 and 4, man.
2 and 4 though?
Yes.
And Mr. Palata Singh, not a distributing counsel for OP number 2 and 4.
My lord, only 2, my lord. Only
4, how he is the manager anyway. District manager of corporation you have to represent. But anyway, Mr. PK Sahu on behalf of 1, 3 and 4, Mr. Palata Singh.
only OP2.
OP2. Stop the Learned Counsel for the appearing for the opposite parties shall obtain instruction.
Maybe prayer, my lord.
नहीं आगे लिखिए सब सबमिशन आगे लिखिए मिस्टर प्रधान 6 amendment submits that the amendment prayer may be allowed. Mr. Sahu, he has served you copy of the amendment application, he says.
Personally, I allow that.
But Mr. Palata Singh says that I don't think now at this stage why amendment, you have to challenge it again.
In the meantime, my lord, they have passed an order, my lord.
Exactly, so you have to challenge it again.
In that order, I have
you obtain from by the next date. By the next date, you obtain. Allowed. The Learned ASC as well as the Learned advocate, the Learned advocate on record for OP number 2 shall obtain instruction. List in the week commencing kebe koile? In the week commencing 30th?
Maybe 16th. Week commencing
14th.
Week commencing 16th.
Short story टा matter है क्या? मोटा ऑटो स्टेट टा रख लेनी
No, or
ठीक अच्छी 23 दिन रे रखो 30 की जो असुविधा नहीं से मोटे वीक रे अपन के व्यस्त होले किनते ठीक है 23 दिन कर दे
okay
potato क्या आसी आती तो तीनटा वर्ड
My lords,
the Passover tila to Nejiba. Actually, they were arguing. So to save time, actually, I passed it over. So it's very similar context. So actually, facts are always stranger than fiction. I didn't. In fact, I had no idea that similar facts are there reported in a particular case.
Most time.
Yes. But Passover kete dakshante? 18. Passover 18. Yes, Mr.
My lord, your lordship is to direct me to file an affidavit of the
yes,
but the husband.
That is at page. That is annex a flag. B was there. Flag B. Place it. You have hard copy or you can use the paperless.
No, my hard copy.
Yes, please.
I sworn so. Hereby solemnly upon state as follows, my lord. That I am the sole opposite party in the instant application. That the instant application filed in obedience to the order dated so and so past petition court. That at the outset submitted, the opposite party deponent has prepared a demand draft of 54,000 byte number so and so, Donor State Bank of India. In petition number, same has been submitted for the Learned Judge Family Code. Your lordship is pleased to direct 2 months, 27,000 to pay. So 54,000 draft I have prepared and I have submitted it before the Learned Court of Judge Family Code.
So you have received 12,60,000 computation.
My lord.
So that is how your pension has been reduced.
My lord. 12,60,000 towards commutation funds. That is usually, my lord, they are all the.
You have received about 40 lakhs.
40 lakhs. 12 and 14. 12, 14, 7, my lord.
14 plus 12 is 36. For rest amount time, you said the age was straight 37.
Around 40 lakhs.
I would have leave encashment 7,41,000.
My lord.
So it comes to 43 point something.
My lord.
So 50 lakhs. तापर आपण 43 पर another 12 lakhs आपण नेचंती कम
नहीं टोटल एटा
टोटल अमाउंट रे जदी
इंटरेस्ट
ना से देखु ना आपण कम्प्यूटेशन रिसीव करचंती 12,60,000
मैडम
12,67,251 होची ग्रेचुइटी 1,50,000 ହେଲା प्रोविडेंट फंड
मैडम नहीं नहीं मिसिक से दिटा मिसिक होजी
तले फिगर मैच केमती करूनी
7 लाख
12, 60, 565 आउट होची 12, 67, 251
मैडम
माइनर कोनटा भीतर पॉसिबल फिर
out of 14 lakhs 17,251 that has been
अरे आपण सेटा जदी कोचोंती जा का जिंसो ताने अलगा अमाउंट केमती हबो क्वेश्चन इज डिफरेंट
gratuity and PF in total it is 14 lakhs 17,251.
गोटे सिंपल गोटे टेबल कर दियंतु दे दियंतु काना नले मो ताकु पर मिस्टर साहू एंड रिक्वेस्ट मिस्टर साहू टू वेरीफाई बड़ कोन चाकरी करथिले आपण गोटे कॉपी सॉल्व कर दियंतु
टीचर
तर मिस्टर साहू को देबे गोटे कॉपी हो
ना मो टेबल कर दे दे नेक्स्ट
टेबल माने जीवन सारा टेबल रे करछनी त से गोटे टेबल करि कि देबे एथरा साहू गोटे टेबल करि कि देबे से आपण को दे काटे जाइछंती गोटे गोटे अमाउंट जो 1260 और जो 1267 पर माने ऑल फिगर्स आर डिफरेंट 12 टा खाली समान अछि 1260 565 और जो 1267 251 आपण सेटा कहउछन दिल जाके एक काम हो That's it. Total pension will come up to rupees 14,611. 40% of computation is taken into account, like this case.
Well, that is
respondent amount is 11,535. And that the respondent in addition to his pension had received encashment of commutation to extent of 40%, 3,84,500. Here the commutation is
12 lakhs
65.
Minor.
And other repair dues, AFPP, AFGA, gratuity leave investment to the tune of 16 lakh 1,000. Here it is at least about 40 lakhs, 40 to 50 lakhs actually. Suppose now you say that 12 lakh is repeated. Let us deduct it comes to at least 40 lakhs. What a significant one, we cannot be oblivious of the asseverations made by the appellant. It has been asserted that the respondent has taken voluntary retirement after the judgment dated 17/2/2012 with the purpose of escaping the liability to pay the maintenance amount as directed by the petitioner. Here actually he has taken, he has retired himself. So the advice kale city padithanta eta jodi 2015 ର ଜଜମେଣ୍ଟ ଏଟା so ବର୍ତ୍ତମାନ 54,000 ଆପଣ ତାକୁ ଦେଇ ଦିଅନ୍ତୁ ଡ୍ରାଫ୍ଟ
54 he has deposited, my client has also received.
Area ରୁ କେତେ ରହିଲା
Area my lord, it is I have to calculate because he has said it is recoverable.
So you also
recoverable from which date it has been recovered.
Both of you take prepare tables. I copy of you solve one Mr. Sahoo. If required, you take instruction. Today I am not asking. I think Mr. Ray will be effective this time. He is prepared with Supreme Court decision. So,
as usual, Mr. Ray is one of the let him go paying the current.
18 नंबर किछ लिखा है नहीं So Suryakanta Das for the petitioner, Mr. Prabir Kumar Ray for the opposite party. The learned counsel for the opposite party, you take your seat, I'll dictate, take some time. The learned counsel for the opposite party refers to the order dated 28/1/2026. Particularly paragraph paragraph 8. Paragraph 8 to submit that the petitioner has filed affidavit dated 25/2/2026, which is on record. Copy of the said affidavit has been served on the learned counsel for the petitioner. The details have been stated in the said affidavit at 4 and 5. The learned counsel shall obtain instruction and prepare a table of total amount received by the petitioner as indicated in the affidavit at paragraphs 4 and 5. It is submitted by Mr. Ray, learned counsel, that draft of rupees 54,000 dated 28/26. 16/2/26. Bearing number of 422-489, drawn on State Bank of India, has been submitted before the learned judge, Family Court, Berhampur. Stop. The learned counsel for the petitioner endorses the said fact that the petitioner has received the said amount. The petitioner shall continue to pay the amount of rupees 27,000 as directed by the learned judge, Family Court, by order ta kete thila earlier order ta by 9 26 केमती हो 26 रे आपण ऑर्डर माने हाई कोर्ट ऑर्डर हला order dated by the order passed in CR.P. number 74 of 2023. Prior to modification by the impugned order dated 13/5/2025. से डेट टा मिले अपन लिखिबे डेट टा कोड दिया है yes list in the week commence in the week commencing 16/4/2024 copy of the affidavit shall also be served on the learned additional standing counsel appearing for the state from whose employment the petitioner has retired working as a teacher. Co school seta?
He has given the pension. You have the first page of the pension matter also.
EPF organization.
EPF
Regional, sorry. I said teacher, my lord, I withdraw my statement.
He is not a teacher, man.
Sorry. EPFO Regional Office, Keonjhar. Employees Provident Fund Organization.
Page 4 of my affidavit.
Page 4. My friend's affidavit.
देखुची, in fact, I'm at page 4, but I'm unable to understand.
The office to which belonged and post last held.
সেটা কোন জায়গায় আছে? এটা আমি পাউনি।
8 column.
সেটা তো EPFO।
This is the last post he has held.
SSSA, स्वच्छासेवी शिक्षा सहायक। Most likely, I don't know.
शिक्षा सहायक
से कौन से EPFO रे काम करथिले कि?
माइल
ओ EPFO रे काम करथिले।
EPF employees.
अच्छा। अरे मिस्टर रे, रबीर कुमार रे को दवा पड़े। Here again Ray versus Ray. Today Mr. Ray is appearing only before Mr. A.K. Roy appeared. No, not Mr. Sahoo. Then next, थोड़ा का टेबल करी दियो तो। कौन लिखे? Shall we stop down Mr. Prabir Kumar Ray on a standing counsel appearing for the EPFO organization. ऐसे तो ये सही से भी EPFO नो छाड़ दियो तो पर देखियो छड़ा जे हे परिवार स्पॉट कौन ऑर्गेनाइजेशन जिनसे असुविधा अच्छा yes
Bachar item 1
It will go on paying the current money.
I think लिख ले
Shall continue to pay January February
आज डायरेक्टेड अपन से डेट टा मते कोई पर लेनी से डेट टा मुझसे भी एक्चुअली कोड लिखा है नहीं से कोड डेट रे ऑर्डर हेतला 27,000
अच्छी तार
को केस रे कोड डेट रे दे परियोजना तो कागज लिखी दे दियो
मॉडिफिकेशन
चेक इट So modification लिखा है नहीं सेटा। Yes. Just 1 second. Just give me a second. पासवर्ड अपन नहीं जानते। मेरा पासवर्ड थे? 15 पासवर्ड। अच्छा अच्छा ऐसे जो जजमेंट पाइले तो श्री रवि कुमार कर सुप्रीम कोर्ट डिसीजन जोड़ा सर्कुलेट हिच ठीक है विल टेक इट अप आफ्टर 1 विल टेक इट अप
1,31,200 टंका पूरा डॉक्यूमेंट्स हमने
ଆପଣ କୋଉଟା ଆପଣ କୋଉ ଦିନ ଡିପୋଜିଟ୍ କରିଛନ୍ତି ମୋତେ ସେତିକି ଦିଅନ୍ତୁ ଡକ୍ୟୁମେଣ୍ଟ ଦରକାର ଆପଣ ଗୋଟେ ପେପର ତାକୁ ସାର୍ ଗୋଟେ ପେପର ଦିଅନ୍ତୁ ସେଥିରେ କୋଉ ଦିନ କେତେ ଟଙ୍କା ଦେଲେ ଲେଖିକି ଦେଇଦେବେ କୋଉ ଆକାଉଣ୍ଟ ସେ ପେପର ଦେଇଦେବେ ସେଟା ଆପଣ କରନ୍ତୁ ମତେ ସେପଟକୁ ନିଅନ୍ତୁନି ସେପଟେ ଆପଣ ମୁଁ ଏପଟ କରୁଛି ଆପଣ ଲେଖିକି ଦେଇଦେବେ ଯୋଉ ଦିନ କଣ ଲେଖିଲେ ଆପଣ ଶୁଣନ୍ତୁ ତାକୁ ପଚାରନ୍ତୁ ସେ ଯୋଉ ଦିନ ଯାହା ଡିପୋଜିଟ୍ କରିଛନ୍ତି so let him sign himself and file it yes affidavit ଟା ଆପଣ ଆଜି ରେଡି କରିଦିଅନ୍ତୁ ନହେଲେ କାଲି ଫାଇଲ କରିବେ
affidavit ବି କରିଦେଇଛି
କରିଦିଅନ୍ତୁ ଠିକ ଅଛି
ଆଉ ସୁକନ୍ୟାରେ ଦେଇଛି
ସୁକନ୍ୟା ନାହିଁ ଆଜ୍ଞା ସୁକନ୍ୟା କଣ ଏତେ ଡିକ୍ରି ସୁକନ୍ୟା ହେଇଥିଲା
ଝିଅ ଆକାଉଣ୍ଟ ରେ ବି ଦେଇଛି
ସେଇଟା ଆପଣ ଛାଡନ୍ତୁ ଝିଅ ଆକାଉଣ୍ଟ ରେ ଆପଣ ସୁକନ୍ୟା କି
ଡିପୋଜିଟ୍
ସେଇଟା ନାହିଁ ଏଠି ସୁକନ୍ୟା କଥା ପଡିନି ଆପଣ କନଫ୍ୟୁଜ ହୁଅନ୍ତୁନି କି ମତେ କନଫ୍ୟୁଜ କରାନ୍ତୁନି ଆପଣ ନାଇଁ ପୋଷ୍ଟାଲ ନାହିଁ डिजिटल ड्यूज रे आपण केते देचंती डायरेक्ट करबे सुकन्या डिपॉजिट आपण डायरेक्शन देखानु ताले बिकॉज़ आई हैव टू रिजेक्ट इट आई कांट रिकॉर्ड जे आपण जोडी जा को देचंती धर तो व्यवहार देचंती जो खुशी हेले बॉर्डर लाख टका देले कैन आई रिकॉर्ड दैट बहुत भलो कथा आपण जो लाख टका दोचंती बट आई कांट रिकॉर्ड दैट आज सैटिस्फैक्शन ऑफ द डिग्री
मो दे दोची सेटा
आपण सुकन्या रे पसंतुनी
नाही
आपण आपण
2,31,000
ଆପଣ ଯୋଉଟା ଯୋଉ କହୁଛନ୍ତି ଯୋଉ ଆମାଉଣ୍ଟ ଟା ଯୋଉ ତାରିଖ ଯେତେ ଦିନ ତାଙ୍କୁ କୁହନ୍ତୁ ସେ ନିଜେ ଲେଖିକି ଦେବେ ଲେଟ୍ ଇଟ୍ ବି ଅନ୍ ରେକର୍ଡ let us not, go on a fishing expedition. nije jani no kon lekhuchu. You must understand that what you are submitting will be reproduced in a record. Yes.
Item 15.
Author again passed over. Hela apon sethi gote dion lekhi. Mr. Sahoo, the necessary corollary is if you are not sure, you should not have.
But I have verified the document.
So verified, so let him write it, and on this date, this amount has been deposited, but don't include birthday gifts and Sukanya and other things.
10,000, 5,000.
Whatever has been deposited. Yes. And rest amount you have prepared a draft.
Draft of rupees 1,50,000.
How he is getting a book of the?
No. He was a check book se dhari kanila sir. Eta dhari kani se.
Check book draft re confusion apon karo hochi.
Na draft.
Draft check re bhatti kar deichandi.
Ha dhari asthili se. This is a demand.
Seta apon karo Mr. Sridhar Nahanti, Mr. Satpathy.
I'm ready.
Se apon associate ki achen receive kari se draft anche dekhouchen.
My lords, I'll ask my associate to be.
But apon by pass over chalu aji gote chalchi kon.
My lords, immediately, my lords.
To kuhuntu. Item 1 nihala 2টা bele. Pass over hela 3টা bele. Author taka by pass over. Kuhuntu se ketala asi ethi asi court number eta this is court number 9.
My lords, within 10 minutes.
Within 10 minutes. Yes, next. 15. So now I'll find it out. I've seen that. I've seen that judgment.
My lords.
Sorry?
Citation, my lords.
Yes, you have the citation. So go through that. So give the citation in a paper. Go to paper. Mr. Mr. P.K. Mahanti, AC for the appellate. Mr. Mohammad Faradis for the respondent. The learned additional standing counsel refers to the order number 4 dated 9/1/2025 passed by this passed by the coordinate bench, wherein it was noted that the issue regarding continuation of delay beyond statutory period is still sub judice before the Supreme Court. Stop. It is submitted by Mr. P.K. Das, learned counsel, who is present in court in another matter, that the said question has been answered and the judgment has been pronounced in the minute. So Faradis, the matter was passed over. Stop. Mr. Faradis, learned counsel, has submits that, not has, submits that so and so pura likhi debe. Is the case where the Honorable Apex Court has answered the question of law. Stop. The learned additional standing counsel as well as the learned counsel for the respondent. Additional standing counsel for the appellant as well as the learned counsel for the respondent shall go through the said judgment to assist this court. List in the week. Notice issue ହେଇନି ପଡ condonation any delay.
No.
ঠিক আছে ଆପଣ ଦେଖନ୍ତୁ ତାପରେ list for orders in the week commencing.
Short.
এটা ଗୋଟେ ଷ୍ଟାମ୍ପ ମାରି ରଖିଦିଅ। ତଳେ ଲେଖିଥିଲେ ଆପଣଙ୍କର ନାଁଟା ପାର୍ଟି ନାଁଟା ଲେଖିଥାନ୍ତି। ଉପରେ ଖାଲି ଏଠି କେସ୍ ନମ୍ବରଟା ପକେଇକି ମେମୋ ଭଳିଆ କରି ଫାଇଲ୍ କରିଦିଅ। author can लिखे। Mr. Mahanti, kindly note this. It may help you or I don't know, but take this.
I'll see it. I only came in short date.
केबे आसपारियो शॉर्ट डेट कहउछन
Short, sir.
we commencing 6 yes next serial jibe na
22.
stopper is moving for the petitioner. Yes, Mr. Bui.
My lords,
Opposite party.
order passed under section 125 CRPC.
Yes.
Petitioner is the husband.
Yes.
My lords, there is no issue, and they are living at the advanced age. 62 years old, the husband, and wife is 55 years old. The wife is residing in her brother's. My lords, when she was unable to conceive, my lord, she voluntarily left the husband's house. And more than 20 years she is residing. My lords, prior to this 125 application, in 2011, my lords, the husband filed a petition for restitution of conjugal rights. That is pending. My lords, that is pending.
So all these you are submitting, it is a case law or it is a speech or a statute?
My lords,
have you read the judgment on this? Which is the leading judgment on this? What you are arguing? Exactly, these are the arguments. Recently, infertility is another thing. The Odisha High Court has dealt, division bench has dealt with that. But what you are saying that because the wife stays within the brother's place, she is not entitled.
No, my lords.
So where is your written statement before the law at trial court?
Written statement
that is how, sir, then it becomes a speech for me. I like your speech. Also, I mean, the way you present your voice also is good. But what I can do, I cannot gather any inference from that. I have to go by the record.
Record re achi.
WS file written statement. You should have stated all these things.
Yes.
Voluntary desertion and all. Where is that?
Seda ଅଛି ମୋ ପାଖରେ ଯେ annexure ଏଥିରେ
ରଖିଲେ ଆଉ କେମିତି ହବ ସାର୍?
LCR ଟା କଲ୍ କରାଯାଏ।
ନାଇଁ ସାର୍, LCR ମୋ କାମ ସେଟା ନୁହଁ। ଆପଣ ଯେତେବେଳେ ଫାଇଲ କରିବେ କୋର୍ଟକୁ ଆସିବେ ଟିକେ ଦୟା କରିବେ ଯେ ସେଟା ପଢିକି କହିବେ ଯେ ହଁ ଆଜ୍ଞା ଆମେ ଏଟା କହିଥିଲି ବୋଲି। ନହେଲେ ଏଠି କେସ୍ କଣ ହବ?
ସେଟା ଡିଲ୍
ନହେଲେ ଯୋଉ କେସ୍ ସେଠି ହବ ସବୁ କେସ୍ ସେଠି LCR ଡାକିବାକୁ ପଡିବ ଯେ ଆରେ କେସ୍ ଫାଇଲ ହେଇଗଲା LCR ଟା ଆଣ। ସେମିତି କଣ ହୁଏ?
ठीक ଅଛି
ଆପଣ ଯୋଉ ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି ଫେର ସବଷ୍ଟାନ୍ସିଏଟ୍ କରିବେ ନା ସେଟା କୋର୍ଟ ଇନଭାଇଟ୍ କରିବ?
ଡେ ଆଫ୍ଟର ଟୁମରୋ ଆସୁ ମୁଁ ସେଗୁଡାକ ମେମୋ
ନାଇଁ ଆପଣ କୋଉଠି ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି ଦେଖିବେ ନା ଫେର ନହେଲେ
ନେଇଛି ଗ୍ରାଉଣ୍ଡ ନେଇଛି।
ଆରେ ଗ୍ରାଉଣ୍ଡ ସେଠି ଏଠି ତ ଆପଣ ବହୁତ କଥା ଭଲ କହୁଛନ୍ତି।
ନା ଏଇଠି ସେଟା ଡିଲ୍
ଏଇ ଯୋଉ ଗୁଡାକ ଡିଲ୍ କରାହେଇଛି ଏଥିରେ
ଆଜ୍ଞା ନା ସେ ଦ୍ୟାଟ ରେଷ୍ଟିଟ୍ୟୁସନ ଆପ୍ଲିକେସନ ହାଜ ବିନ୍ ଏକ୍ଜିବିଟେଡ।
Restitution execution कौन हो? Section 9 file में 125 maintainable no.
Now wife has
Odisha High Court decision अच्छी on this.
No, the wife has not substantiated the evidence.
ଆପଣ जोड़ा कहउचंती that is not a matter of speech, that's a matter of record.
Record रे से
ଆପଣ जोड़ा written statement ଦେଇचंती
125
सब बुझी हेबनी ଯଦି ଶୁଣିବେନି ବୁଝି ପାରିବେନି ମୁଁ କଣ କହୁଛି। Section 9 फाइल ले 125 मेंटेनेबल की नो सेटा ऑलरेडी एक्साक्ट डिसीजन अछि
ना सेटा मु कहउनी।
सो सेटा 125 कहउचंती जे सेक्शन 9 फाइल हेतला आपण एग्जीक्यूट करचंती सेटा सेक्शन 9 एप्लीकेशन सो 125 इज नॉट टू बी ग्रांटेड।
नो
अतल काई सेटा कहउचंती आपण फेवर आर्गुमेंट करिवे ना
सेतिरे से वाइफ कहउचंती मु तांको सहित रिजाइड करिविनी तेणु मु कहउथली सेठी मु रिटन स्टेटमेंट देइथिली एवं एविडेंस भी लीक
सेटा आपण केमिति प्रूव करचंती कोन हेची सेटा केवल ଆପଣ ଦେଖିବାକୁ ପଡିବ ଆପଣଙ୍କ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଆଉ ଆପଣଙ୍କ ଜଜମେଣ୍ଟରେ କୋଉଠି ଡିଲ୍ ହେଇଛି ସେଥିପାଇଁ ବର୍ତ୍ତମାନ ଆମେ ଷ୍ଟ୍ରଗଲ କରୁଛୁ ଆପଣ ସାର୍ ମୁଁ ବି ଷ୍ଟ୍ରଗଲ କରୁଛି ଆପଣ ତ ଉଠଉଛନ୍ତି ମତେ ଉଠେଇବାକୁ ପଡୁନି ପେପରଲେସ୍ ସ୍କ୍ରୋଲ କରିଦଉଛି କିନ୍ତୁ କିଛି ମିଳୁନି ଆପଣଙ୍କର ଆପଣ ମତେ ଦେଲେ ମୁଁ ଦେଖିବି
ଡେ ଆଫ୍ଟର ଟୁମୋରୋ
ଆଉ ତାହେଲେ କଣ କରିବା
ନହେଲେ ଏଇ ଯୋଉ ଲିମିଟେସନ ଟାରେ ନୋଟିସ
ନାଇଁ ନାଇଁ ମୋର କାମ ନୁହେଁ ଲିମିଟେସନ ନୋଟିସ କରିବା ଆପଣ ଯେମିତି କହୁଛନ୍ତି କେସ୍ ଫାଇଲ ହେଲା ଏଲସିଆର ଆଣନ୍ତୁ ପଢନ୍ତୁ ଦେଖନ୍ତୁ ଯେତେବେଳେ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଅଛି କି ନାହିଁ ଆପଣ ଯଦି ମେରିଟ୍ ଅଛି ତାହେଲେ ଲିମିଟେସନ ସବୁ ନିଅନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ କିନ୍ତୁ ଆପଣଙ୍କୁ ୟୁ ହାଭ୍ ଟୁ ଗो ନଟ୍ ମାଇ ପର୍ସନାଲ ଚଏସେସ୍
ଆଜ୍ଞା ଡେ ଆଫ୍ଟର ଟୁମୋରୋ
the matter the Lord Counsel for the petitioner after arguing the matter for some time has adjournment to address further list in the week commencing କଣ ଅର୍ଡର ଗୁଡାକ ସବୁ ପଠେଇ ଦେଲେଣି ଆଜି କଣ ଆଉ ସେମାନେ ଜଲ୍ଦି ଚାହୁଁଛନ୍ତି
ଶନିବାର ଦିନ ଆସିବେ ଶନିବାର ଦିନ
ଶନିବାର ଦିନ ଆପଣଙ୍କର ତ ନାହିଁ ସେଟା ତ ଆପଣ ରେକର୍ଡରେ ନାହିଁ ତାକୁ ଆଣିବେ ଖୋଜିବେ
ନା ନା
ଆପଣ ତ ଗ୍ରାଉଣ୍ଡ ସେଟା ପ୍ରିପେୟାର କରିଥାନ୍ତେ ଦେଖିକି କରୁଛନ୍ତି
ଗ୍ରାଉଣ୍ଡ ରେ କରିଛି
ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଦେଖିକି ଗ୍ରାଉଣ୍ଡ ତିଆରି କରିଛନ୍ତି
ଆଜ୍ଞା
ଭେରି ଗୁଡ ତାହେଲେ ୱିକ୍ କମେନ୍ସିଂ ଆପଣଙ୍କର 16 yes
34 respondent number 3 my lord can you take it Mr. Samantra is a busy person so kindly take
Mr. Karunakar Naik senior panel counsel for the appellate Mr. Jitendra Samantra
yes
on behalf of R3 କାହିଁକି ଚାହୁଁଛନ୍ତି ସାର୍ ଏଟା ତ ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟର ହିୟରିଂ କରୁନାହାନ୍ତି
what to time
The Lord Counsel for the appellant, the matter has been listed for admission hearing. Lord Counsel for the R3 seeks adjournment to address arguments. List in the week commencing 13/4/2026. Mr. Naik କିଛି ହେଇପାରିବ ମିଡିଲ ପାଥ ଆମିକେବଲ ଆପଣ ଟୁଥ ଆଣ୍ଡ ନେଲ୍ ପୁରା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ଆମେ ଏବାଡେ ଏଗେନ୍ଷ୍ଟ ରେ ଆସି
କରେକ୍ଟ ଏନାଉନ୍ସମେଣ୍ଟ ହେଇଛି ଆପଣ କେତେ ଯଦି କିଛି କରିପାରିବେ ଟକ୍ ଟୁ ମିଷ୍ଟର ସାମନ୍ତରାୟ
ଆଜ୍ଞା
No, I'm not. Obviously, you have the freedom to argue your matter, but if anything can be done by the next time, next date at least, because these are land acquisition matters is an area where mediation will work.
I will have a talk with my and therapist.
Yes. Try to reduce these numbers.
Yes.
And if any small amount is there, but it is worth arguing, please ignore. Try to argue that so that some law will be settled.
Minor.
Yes. Yes, please. ଆପଣ ଦେଖନ୍ତୁ ଖୋଜିକି ପାଇବେ ସେ ଆଜି ତ ଆଫିଡେଭିଟ୍ ଦେଲେ ଆପଣ କପି ଦେଇଦେବେ ମୁଁ କହିବି he will serve you a copy
25 I was praying in the morning.
Yes.
Time you grant for the
Mr. Rakesh Sharma for the
petitioner.
Mr. Mohanty senior advocate is not
there. Mr. Mohanty will come.
Mr. Sanjit Mohanty along with Mr. Rakesh Sharma on a distracting counsel for the petitioner. Mr. P.K. Sahoo, additional standing counsel. For the opposite parties, plural. The matter being in the list was mentioned by the learned advocate on record for the petitioner, Mr. Sharma, learned advocate on record for the to be adjourned for filing rejoinder to the counter filed by the opposite parties 1, 2, and 3. Mention लिख लेता mentioned at the beginning of the day's proceeding कर दिया The adjournment sought for is objected by the learned additional standing counsel.
Put the line, sir.
I'm giving a judgment on this issue.
ଟିକେ ରୁହନ୍ତୁ ଟିକେ ଡିଷ୍ଟର୍ବ କରିବା ଏଇଟା ଟିକେ ଛାଡନ୍ତୁ କଣ AC. Accordingly, the matter is taken up when it reaches. Stop. The Lord Counsel, Mr. Sharma, reiterates his prayer for adjournment. How much, Mr. Sharma?
4 weeks time may grant.
For 4 weeks for filing rejoinder to the counter. It is submitted by the Lord Additional Standing Counsel that the counter was filed on 16/1/2024. Copy केवे सर्व है ना?
14/7/2025.
Copy of which has been तभी stop कर दिया. It is submitted by Mr. Sharma that the counter was received on
14/7/2025.
After it was filed after Kebega case.
If your lordship sees the order dated 14/7/2025.
After the counter was filed 8 years after filing of the writ application. It is submitted by the Lord Sapara. It is submitted by the Lord Additional Standing Counsel that stay is operating. Stay by order dated. Stay order dated. Stay order 9. No coercive action.
No coercive action.
Interim order dated 23/11/2016 is operating. Stop. Upon perusal of the order dated 23/11/2016, it is indicated that notices were issued and directing the Lord AG appearing for the state to file counter by the next date, and the matter was directed to be listed in the week commencing 2017. Stop. However, the counter was filed on it, जो 24 order दाखिल है, यहाँ लिखते हैं on it dash para. Considering the submissions of the learned counsel for the petitioner as well as the learned additional standing counsel for the opposite party, further time is granted to file rejoinder. Further time is granted to the petitioner to file rejoinder by 4 weeks.
Months.
Rejoinder to be filed by Ajuchi 5 20 तारीख ही परियो ना नहीं 25
by 25th.
by 25 4 weeks में 3 weeks हो है ना by 26/3/2026 upon serving copy thereof on the learned counsel for the state list in the week commencing 6/4/2026.
Interim order to continue.
The Lord AC relies on the decision rendered by the Honorable Apex Court in civil appeal number relying the judgment of the declared 21/2023 passed in civil appeal number 220/2023 into bracket Mahanadi Coalfields Limited versus State of Odisha. To submit that the issue involved in the present application is covered by the said decision. It upon a copy never na reference
counter देइछ पर extra अच्छे I can give counter रे भी देइछ
Counter refer I'll take a printout.
Okay. The learned counsel for the petitioner shall also respond to the submission of the AC regarding the matter being covered by the judgment of the Honorable Supreme Court. They do. Yes, next please.
26 on behalf of SN Jena, my lord. Next week, my lord.
So Jena is appearing on only one matter. Other matters, Mr. Naik is appearing. Two matters.
Naik is the interim order now.
Mr. Sharma has a matter should have come with the interim order passed earlier shall continue. Interim order dictate जो था कुछ 23 से करना चाहिए.
Obliged.
Shall continue till the next date of hearing.
Obliged.
No, you mentioned that, but since I was dictating, I lost the track.
No, I'm sorry.
Yes. Your name, sir?
Rasmikanta Sahoo.
Power 9.
No, I have no power.
Who matter appear coaching?
Yes.
For other side?
I am for the university, my lord. This is and
Sir, you are writing R.K. Sahoo.
R.K. Sahoo.
So R.K. Sahoo on behalf of S. Naik for the petitioner. 26. Mr. P.K. Sahoo, Additional Standing Counsel for the opposite parties 1 and 2. 1 and 2.
Yes.
Mr. A.K. Nath for the Mr. A.K. Nath, you are also having one P.K. Sahoo with you?
No, I am for
Or the same P.K. Sahoo?
I am for the register, my lord.
No, A.K. Nath, P.K. Sahoo, S.K. Raut. Who is the P.K. Sahoo?
My associate.
President decides towards your right or
No. Like this. I am for the OPIC 4, my lord.
So Mr. A.K. Nath and Mr. P.K. Sahoo for the opposite parties 3, 4 and 5. Learned Counsel for adjournment is sought for on behalf of the Learned Counsel for the matter is listed for admission hearing. Adjournment is sought for by the Learned Counsel for the petitioner. List in the week commencing. These are complete.
Yes,
complete.
Regional organization.
List in the week commencing 24-26.
Regional not file. They will not.
Agenda फाइल करिया पे आपण टाइम नै चंती करू नांती फेरे अर्जन एगेन आउथरे फेरे टाइम नै आबो देखंतु कल लिखले 24-26 since the matter is listed for admission for after notice admission hearing the parties are expected to complete the pendings as well as exchange the same. Yes, next.
Interim order is there, madam.
27 no 3 matter अछि सब item रे भी same order 1 to 8 in view of the order passed in the order to connected WPC 12704 of 2018 list in the week commencing 24 12828 of 2018 in view of the order passed in WPC 12704 of 2018 list in the week commencing connected WPC list in the week commencing 24-26. Yes.
Interim order is there.
Interim order as passed earlier. First elected shall continue till the next set of hearing.
Item 27.
Sabutari interim order as passed earlier. Sabudakar elected.
So
27, my lord, I am for the contemptuous matter. I have taken consent from Mr. Das, my lord, advocate for the petitioner, my lord. It must be taken up next week.
Bhagya Sundar Das for the petitioner. Mr. M.R. Pradhan for the Mr. Mahapatra's name should be mentioned. So Ananda Mahapatra, senior advocate, along with Mr. M.R. Pradhan for the opposite party. Learned counsel for the petitioner, learned counsel for the learned instructing counsel, Mr. Pradhan. For the opposite party submits that he seeks for adjournment, which he has intimated to the learned counsel for the petitioner.
Man.
The matter shall be taken up in the week commencing. How much time?
My lord.
24-26. Yes, next.
29.
My prisoners.
The Satyaranjan Patti for the petitioner. Ms. Mahapatra, Mrs. Mahapatra?
My name is here for the opposite party, but I have no instruction.
Sorry? What is this, Mr. Patti? You can win a case, but you are not disengaging the lawyer also. She says her name is there, but she doesn't know anything. Let us adjourn it because after notice matter cannot proceed in this way.
Can I proceed?
Yes, Mr. Patti, can I hear?
Admitted, my lord.
The Satyaranjan Patti for the petitioner. MS Manasi Mahapatra for the opposite party. Learned counsel for the opposite party submits that she has misplaced her brief, though her name appears in the cause list, and seeks for accommodation. So the matter is adjourned. Matter listed for after notice hearing is adjourned to be taken up in the week commencing. 24/4/26. Yes.
Can I take a copy from?
Yes, just move copy.
If so, the Lord counsel for the opposite party shall have liberty to obtain soft copy from the registry of the court. The Lord counsel for the petitioner shall do well to. Ago ଆପଣଙ୍କ ନାଁ ଅଛି ନି ଆଗ ଦେଖନ୍ତୁ ସେ brief transfer ହେଇ ଯାଇଛି, just check it. The Lord counsel for the petitioner shall do well to copy.
Item 30.
Yes, please.
Well, my senior is in BCL.
Password कर दो, connect ही ना थी. Just one password. Next call करूँ तो.
31.
Tripathi, your matter, Mr. Bal. 31.
I'm praying for an adjournment as per the conversation about the withdrawal, but no one is appearing from the petitioner side.
ଆପଣ mention କରିଥିଲେ କି Mr. Barik?
Mention
31 mention नहीं. लिखिए petitioner none. You are Miss D. Sahoo.
Rituparna Chatterjee.
Miss Rituparna Chatterjee for the party. None appears for the petitioner when the matter is called. What was the last order, Miss Chatterjee? Any idea?
It was adjourned on 21/26. It is adjourned for 23rd of Feb.
I'm for the petition. Acha, Mr. Abid Sahu. Tale 31 Mr. Abid Sahu for the upon to not thile na not thile jani parleni. Apun asile. Mr. Abid Sahu for the petitioner. Please Rituparna Chatterjee, you want to withdraw? No instruction or adjournment.
Kindly take it on next week.
Okay. The Lord counsel for the petitioner seeks and has adjournment. So the matter is listed for hearing after notice. List in the week commencing 13/4/26. से कौन कौन तापर बुझोनी जान नथिबे, talk to your senior.
Yes, ma'am.
Might be that they want to.
Thank you.
The matrimonial matter.
Thank you.
Next.
Item 32.
Ms. Rita Singh for the petitioner, Mr. Devidatta Mahapatra for the opposite party. Yes, 32.
May I please, Your Honor? I am for the petitioner.
Passover or oil lagi?
Sir, more rahi again. Again.
Acha, since senior is appealing, so he has to take a precedence.
ଏଥିରେ ସାର୍ ଦେଇନାହାନ୍ତି written note ଡେଟ୍ ଚାର୍ଟ noting ଅଛି.
This is item
30.
30.
Mr. N.K. Mishra, senior advocate, along with Miss
Adesha
Annapurna. Adesha Annapurna for the petitioner.
Petitioner.
Mr. Amarendra Prasad Rai, standing counsel. Standing counsel for the opposite parties. So this has to be heard. This has completed.
This has to be hard here. This has to be hard here.
Pleadings are complete.
Yes, sir.
ତାହେଲେ ଆଉ ଦିନକୁ ସାର୍
Has to be. Even if suppose the earlier bench has heard, partly I have taken. The pleadings are complete. The matter shall be listed. It should come for hearing or for admission.
Sir, here is asu which nahi jemti kahi sir. It has to be hard.
Sir, listed for admission in the week commencing. Date 24/4/26.
There is an interim.
Interim order as passed earlier shall continue till the next date of hearing.
Sir. Great.
34 महापात्र 32 ना पण ଆପଣଙ୍କୁ ପାସୱାର୍ଡ ପଚାରିଲେ ଆପଣ ଏଟା ବି ଯୋଉଟା ଆପଣଙ୍କର କନେକ୍ସନ ରହୁନି ଆପଣ ନିଜେ ଦେଖିବା କଥା yes
Yes, ma'am.
Miss Singh.
In this case, my lord, today I filed one IA with some of the relevant documents which I obtained from the lower court. So that IA has not been attached here. And I will solve the copy also. today.
ଆପଣ ଏଇଟା ମେନସନ କରୁଥିଲେ ଆଇ ନା ଆଉ ଗୋଟେ ନା
एक time पे एटा ही मेंशन करतली मॉर्निंग फर्स्ट आवर
ଆପଣ ଆଉ ଗୋଟେ ବି ଆଜି ଆପଣ ଯୋଉଟା ବି ସାଇନ୍ କରୁଛନ୍ତି they are also with a map
no ସେଟା
Only this one.
सेटा फ्रेश है
Have a glance. Last photo. 22/1/20.
ଆପଣ ଆଇ ଫାଇଲ କଲେ କଣ ହବ ଆପଣ କେତେ ଟଙ୍କା ଦେଇଛନ୍ତି କେତେ ଟଙ୍କା ଦବାର ଅଛି
1000 ଦେଇଛି at the time when the interim order was passed
କେତେ ହେଲାଣି କେତେ ଡ୍ୟୁ ଅଛି କେତେ ଦେଇଛନ୍ତି keep it simple and straight
may I place something my lord may
sorry
My lord, the proceeding has been stayed.
obviously it was so
may I place one thing my lord. Here the opposite party is a government employee. Being a wife, she is a government employee, and what she had done, she has given the.
when you start arguing these matters
Yes.
don't give a speech
No, madam.
so your purpose is to read law
Yes.
law is the section and the Supreme Court decision
25. Yes, madam.
this exact argument has been answered by the Supreme Court
Yes.
government employee whether entitled for payment
Or not.
all those things so you derive your strength of your argument from that decision
My submission is that.
don't make submission direct law
No, she has filed.
This is a court.
She has obtained this order by giving the false affidavit, wrong information to the court, to the trial court.
This court is saying which court will modify that if wrong information
The trial court.
so obviously why
This court has the power to initiate proceeding. Why, being a government employee, why she will file a wrong? It will set a good example. The being a government employee,
we are not inviting litigations that wherever some wrong is happening today while traveling here you have seen so many wrong things.
Yes.
He has seen that's not the please don't argue
Sir, being a personal
madam, this is not something very dramatic let us confine to the case if she has done something you bring it to the notice of the court which is empowered to do that
regarding if court will pass an order, I have passed that IA and with some relevant document.
how much direction is there by the court this is not the stage for entertaining further documents
Why, madam?
whenever you are making a submission in the court which decision is on this point
I will decision भी देबी sir. Why? Because my husband
देबी काहेकि ना आपन जेतु स्टे नेला पर हेई परिबनी you go through Samim Faruqi and Rajnesh versus Neha the 2 points you are arguing exactly have been dealt with by the Supreme Court that what is the extent
my husband
right now I'm passing it over you go through that decision because there is no unlikely it is unlikely for a lawyer to read decision
my lord,
so I'm asking you to read it no
where I will get I am depending on father pension my submission
it is a matter of evidence not a question to be asked
sir filing IA
not here you cannot improve upon that read paragraph 19 no you have to read it aloud because it's
from the
এটা কোন নিরব পঠন করিবে না কোন তাহলে why
from the above invocation of law, it is limpid that the obligation of the husband is on a higher pedestal where the question of maintenance of wife and children arises. When the woman leaves the matrimonial home, the situation is quite different. She is deprived of mere comfort.
কোনটা পড়ছো কোন প্যারাগ্রাফ পড়ছো
19.
হ্যাঁ ঠিক আছে
She is deprived of many comfort. Sometimes her faith is in life reduced. Sometimes she feels she has lost the tenderness friend. There may be a feeling that her fearless courage has brought her these misfortunes. At this stage, the only comfort that the law can impose is that the husband is bound monetary comfort. That is the only sitting legal bar for she cannot be allowed to resign their destiny. Therefore,
Read slowly. So you are on. In fact, you are not noting any punctuation. Comma, full stop, you have to stop. See.
For she cannot be allowed to that it is the only soothing legal balm, or she cannot be allowed to resign the destiny. Therefore, the lawful imposition for the grant of maintenance allowance.
Then can you read further?
In the 20 para. In the instant case, as it's seen, the High Court has reduced the amount of maintenance for rupees 4,000 to rupees 2,000. As it manifests, the High Court has been oblivious of the fact that she has to stay alone. Needless to say, the order of the learned family judge is not manifestly perversive. There is nothing perceptibly which could show the order is a statutory of errors. In fact, where the order is statutory of errors. In fact, where the order is based on the.
Actually, you are reading it so many words wrong that I have prompted. They are not having the copy.
Proper application of evidence on record. No revisional.
I will read that slowly.
Yes, madam. No revisional court should have interfered with the region on the basis that it would have arrived at a different or another conclusion.
Kindly stop there. Now, if I do accept here now, then it is directly on the face of it Supreme Court order.
One thing is.
Then can you read the last line?
I think I say in this 19 para what she had written, deprived lady, where she is deprived.
No, that's not the matter. That is not regarding whether this lady is deprived or not. That's not. You read para 20 then. Read further.
Yes, ma'am. When substantial justice has been done, there was no
substantial justice has been done.
There was no reason to interfere. There may be a shelter over her head in the parental house. For other real expenses cannot be ignored. Solely because the husband has retired, there was no justification to reduce the maintenance by 50%. It is not a fortune that was just showered on the wife. That is a reduction. It only reflects the non-application of mine, and therefore we are unable to sustain the said order.
So that is the problem.
My lord.
Now, one Supreme Court has said already a High Court, non-application of mine. So I have some mine, maybe non-application, I may be thinking that this judge doesn't apply mine. But I can't invite that kind of a situation.
My lord.
So the problem is that the worst part is that I will start collecting evidence.
My lord.
If you read, which you have not read successfully, I will now read this para 90 of this. Read the citation and then state para 90. Read the heading, para 90.
Para 90.
C.
Where wife is earning some income. 90. The courts have held that if the wife is earning, it cannot operate as a bar from being awarded maintenance by the husband. The courts have provided guidance on this in the judgment.
So the problem is that you are trying to pass the order without applying mine. So that Mr. Mahapatra will go to Supreme Court and said that it is directly. So that I cannot do that.
Okay, if what my lordship is saying.
No, my lord is not saying. My lords in division benches, larger benches of Supreme Court.
My lord, what amount has been made? It had been less amount. 6,000 evidence to which evidence 6,000 reduced.
This is not a question of bargain.
Bargain. How she gain the
if you let the interim order be vacated.
How she gain over the court by giving the false affidavit? It is also a violation of.
Could be very serious allegation.
Yes, my lord.
You are recorded.
Yes, my lord.
You will be considered for contempt.
My lord, that
without any evidence, you are officer of the court.
Evidence is
and you are making a statement in High Court that the petitioner has gained over the court. No,
my lord, that's evidence I have given in the IA, my lord. Made one week time investment.
No, that's evidence I cannot entertain. I cannot entertain IA. That is how I have told you that I am doing by law.
I also call for.
Let's see that you are free to say anything.
No, my lord.
You expect today to do. That the court is gained over by the petitioner. What is the other?
Let the lawsuit call for the LCL, my lord.
Please don't do that. So this is not a chance.
pay my, I'm unemployed, it's unable to pay from my side.
We don't ask questions. Being a pauper is matter of evidence before the court. It is there. If you read further, you'll be aware. It can be done. It can be done. Just Mr. Ray and Mr. Das. It was there that one can plead very well that I am unable to pay for the because he has to prove it. It is very clear in that particular decision. It's not that difficult also.
ଆଉ ଗୋଟେ ସପ୍ତାହ ପରେ ଆସୁ sir.
ନାଇଁ ସେମିତି କରନ୍ତୁ ଏଟା don't bargain regarding, you have to be clear to your client that adjournments because you are not
the document is there, my lord.
Document before the trial court, whether you are having it or not having it.
Now also having
Before the trial court, show from the record
the filing court.
So I can help you. I am not inviting here. You must understand that while filing the application, you have not filed. That's it. What is the amount due, sir?
My lords, it is 6,000 rupees from 9/1/2020.
How much he has paid?
7,000.
Total 7,000 he has paid. 72 months. Four lakh 32,000. How much you deposit for continuing the stay? That much I can help you. Out of
Instruction point.
4,32,000.
Instruction point. How can I say?
Pass over.
Copy.
I can't pass illegal orders. I have a difficulty. You must understand that the Supreme Court is steering. The Supreme Court order, sorry. Supreme Court steering that.
I will take the instruction now.
On your tomorrow.
Tomorrow I'm out of Tuesday also more out of matter. Tuesday, my lord. On 10th.
The hard nodded counsel for the petitioner at length. You take your seat, both of you. Take your seat, I'll dictate the order. It'll take some time. The petitioner husband is before this court. Seeking revision of the judgment dated 21/9/2024 passed by the learned judge, Family Court, Bhubaneswar, in criminal proceeding number 07 of 2020. Stop. By the said judgment, the petition under section 125 of the Code of Criminal Procedure, claiming a sum of rupees 50,000 per month filed by the wife in the marriage, was allowed. However, the court directed, the learned judge family court directed rupees 6,000 as maintenance, monthly maintenance from the date of application filed. That is Law 8/2020. For issuance of notice before the coordinate bench, a stand has been taken as recorded by the coordinate bench by order dated 21/3/2025 that the petitioner husband is doing nothing. The opposite party wife is working as a assistant revenue inspector in the office of the Tahsildar Cutoff. Therefore, it cannot be said that the wife is unable to maintain herself so as to entitle herself for maintenance. On being asked, the learned counsel for the petitioner submits that the petitioner husband had chosen in default of the entire amount due, which comes to rupees 4,32,000 into bracket likhibe 09.01.2020 to 09.02.2026. Equal to 73 months into 6,000. That is equal to rupees 4,38,3,000. 30. 4,38,3,000. The learned counsel, Mr. Tripathi, Mahapatra, you are senior with Tripathi. That's how. It's good that still you are having giving impression of your senior. Mr. Mahapatra submits that the petitioner has paid 7,000 out of the said due of amount rupees 438,000. Both the issues raised before this court, the wife earning, oblique capacity to earning, as well as scope of interference of this court, has been answered by the judgments of the Honorable Apex Court. In Rajneesh versus Neha, colon into bracket 22 close to SEC 324. Para 90. C. C see where wife is earning some income. $90, then 90.1, 90.2, 90.3, 90.4, 90.5. Children achanti. Quote karta. In Samima Faruqi, colon, into bracket 2015, bracket close 5, SCC 705. The Honorable Apex Court have considered the scope of interference by High Court in orders granting maintenance under Section 125 of CRPC. Paragraphs 19 and 20 of the said judgment being opposite are reproduced. However, this is the clear provision of law. The learned judge, family court, while considering the application under Section 125 CRPC, has dealt with the evidence public material on record that the petitioner husband was then working as a senior project engineer, Lloyds, LLOYDS, with salary of rupees 1,00,000,000 per month, apart from rupees 5 lakh per annum from agriculture. The details of the gifts received by the husband during marriage have been noted at paragraph 5. The Lorette Court has also noted the fact that the petitioner wife, before the said court, has mentioned her designation as ARI in the office of the Tahsildar Cuttack. At this stage, the Lorette Counsel for the petitioner was asked to for conduct the hearing order whether the petitioner will secure the decree, that is the amount awarded by the Lorette Court, which comes to rupees 4,30,000, 4,38,000 minus 7 कर देवे, equal to 4,31, 438,000 minus 7,000 is equal to 431,000. Comments that C wants to bring on record further documents by filing affidavit, which in view of the pronouncement of law in Samima Faruqi's Supra is not permissible. She further submits that she will obtain instruction regarding the amount, whether and how the amount will be secured for sustaining the challenge. Stop. The matters will be listed for orders in the week commencing. Next week, in the week commencing, still for further time is granted if you want to sustain, because today the matter has been finally heard. At least I cannot improve on this, whatever is there. The week commencing. Please, Mr. Mahapatra. It's not sir.
6.
Give title please. PC 3-26. The hearing actually is over. Yes.
That's with regard to that observation, paragraph 5.3 is very clear.
5.3 of?
5.3 of the judgment, my lords.
No, actually, I have kept something for the next case. Because non-compliant persons also, they are not listening to the lawyer. And missing now the judgment has been dictated. Why the court, Supreme Court, has that non-application of mind of the High Court? Because you are to educate me. The lawyers have to assist me. If I rely on your submission and pass an order, since some documents are filed, it is stayed. Since she's working as a ARI, it is stayed. That is how I invite observation of the court that non-application of the
To say that it is also contempt to court also, because being a government employee, out of court I am
You are
submitting,
not
my lord.
listening. You are, apart from committing contempt of court yourself, you are not listening. The court has noted that she is working as ARI. She has stated before the court. If you do not read the judgment, this is the problem. And you have said that the judge who has recorded that she is working has not granted sufficient. What is the value of 6,000? He has been gained over. You have stated it is a part of record now. It's available, you can see. This you should avoid because you are officer of the court. You are making a submission that if she is ARI, she is not entitled. Otherwise, you would have got 60,000, whatever. So, example, suppose the court is inclined to give her 20,000, but has given her 6,000. Why? Because the court has recorded she is working as, in fact, court has rejected that objection. Upon 5.3 সেটা কହୁଛନ୍ତି
ସେଇଟା ହିଁ କହୁଛି
ତାହେଲେ
ସେଇଟା ହିଁ observe କରିଛନ୍ତି
ନା ରିଜେକ୍ସନ ଟା ନୁହଁ 5.1 5.2 ଉପରେ ପଢନ୍ତୁ ମିଷ୍ଟର ସିନ୍ସ ଆପଣ ଏବେ ପଢି ଦିଅନ୍ତୁ ସେ ତ ପଢିଲେଣି ବହୁତ ପେଜ 17 ଦେଖନ୍ତୁ
page 17
yes on perusal of the disclosure
on perusal of the disclosure statement of assets and liabilities furnished by laws that also
please read that because she has
furnished by the petitioner. It is found that she has mentioned as her designation ARI
Assistant Revenue
Inspector in the office of Tahsildar Cuttack Sadar. So the objection raised by the learned counsel for the
petitioner exhibiting B and B is unsustainable. Even B by B1 has been granted at your instance, admitted at your instance. And you are saying that the judge is gained over. Rejected like कौन कोई था Now because you are seeing Mr. Mahapatra, he will gain over everyone. That should not be. Actually, she made this comment after looking at you only.
No,
yes. The court has rejected the objection. Admissibility of B and B1 showing that he is working as ARI has been rejected. Yes, your matter, Mr. Sahoo.
Matter.
Date के देने तो पासवर्ड रही ऑर्डर टा कौन लिखिथिले मन को की लिखिथिले के दत्त सर को डाकी दी लास्ट लाइन टा कौन थिला
दिस इज द डिग्री
तो एटा आपनकर जोटा केबे हला
just
one second.
Judgment la 19/4/2022 with effect from from the 7/12/2018 ରୁ ଦବା ପାଇଁ ଅର୍ଡର
कोन 2,31,000 ଟା रिड्यूस हे गला कि आपण केते कहउतले 2,31,000
2,31,000
बर्तन सेटा कमी कि 1,05,000 हे गला
ना 2,31,000 देछि
कोठी हला
फास्ट देखंतु सेकंड मतलब
अरे नहीं आपण ताले कोडे आपको फोटो आपण गाड़ी परिबेनी
2,31,000 देछि सर पछपट पेज रे देखु दीटा अकाउंट रे मु देछि पैसा आई हैव मेंशनड इन टू अकाउंट गोटा कर
दिबोटा आप देखो एटा को आपण ताको दियंतु से आपण अछंती अदर सेट पे तो
आज्ञा
अच्छा आपण पे पासवर्ड होइतला आई फॉरगॉट
डीडी टा भी दउची 1.5 लाख टंका
एटा को जेरस करके सर को दे दियो
आज्ञा
कौन तू लास्ट लाइन टा लिखिए तो डिटेल करता है हो मुझे फोन चला है साइन कर लेटा
हां
the said the matter was again passed over as requested by the learned counsel for the आपण होचंती
से साइन कर दो
तो कोर्ट से साइन कर देबे जेरस करी ताकू दिया और मेमो लिखि दियो
आज्ञा
ताकू कोन देले से कोन साइन करी अरे बुझी पाउ ना तो कमिटी ऑफ एरर्स दियो सेटा जो बाकी साइन से साइन करछंती तो ताकू पे दोचंती तो जेरस करी से नउचंती
अरे साइन करछंती बा
पछपटे करछंती
हां पछपट लास्ट रे करछंती
ना पछपटे जो लास्ट न था यार जो फोटो सेइथरे करंतु से बुझी रे रासी गरे अरे उभय पेज रे साइन कर दियंतु ताको दो कोन Lord counsel for the opposite party. अगर opening sentence लिखा तो the matter being marked to be taken up at 2 p.m. is called at 2 p.m. सेटा खाली नौ रहला तापर तो अपन पूरा कंप्लीट कर देछन हला तापर जोटा अगेन पास ओवर करले the matter is again taken up at 4:20 actually 4:20 दा उस अमेंडमेंट हे गेलन taken up at 4:17 p.m. The Lord counsel upon another
Lakshman Soren.
Mr. Lakshman Soren is present in court. Mr. S.P. Satpathy, Lord counsel for the opposite party. Lord counsel Mr. Lakshman Soren is present in court on behalf of the opposite party. His leader, Mr. Satyaprakash Satapathy, is present in the virtual court, High Court of Orissa, Khurda at Bhubaneswar. चला गोटे मेमोटा कॉपी टा देबो सेटा गोटे
चेक नंबर टा खाली पड़ी
जस्ट वन सेकंड कोन देबे एटा तो
डीडी टा देबी
मेमोरी में एनपोस्ट कर दियो memo of date is filed by the learned counsel for the petitioner including a statement of payments made. The copy of the said statement, copy of the memo along with the statement. नहीं अगर statement copy of the memo नहीं चला काटी ले तब पूर्व कौन लिख ले copy of the statement. Memo of date is filed. And demand draft
of rupees 1,50,000.
1,50,000 dated.
Dated 5/3/2026.
Number dash
60908.
सेटा लिखियो भूल भाल हो सेटा फोटोकॉपी ताको दिन पठान दो आउथरे फोटोकॉपी करो ड्राफ्ट देखि फोटोकॉपी करन तो सर यस अपन दे जान तो 4:20 हेलानी गोटे कोर्ट रे चल लिखी दे पूरा तो copy of the said memo along with copy of the statement the details copy of the statement containing details of payments made along with the demand draft in original is handed over to the learned counsel Mr. Soren appearing for the petition for the opposite party. The receipt of the demand draft is also endorsed in the note sheet maintained by this court, countersigned by the court master. So, the learned counsel for the opposite party has adjournment to obtain instruction in response to the statements, the details of the statements of payments made by the next date. The amount of the demand draft, the amount of rupees 1,50,000, 1,50,000 demand draft shall also be received by the opposite party. List for orders in the week commencing. केबे कोन तो सर आपण कोन आपण आज बहुत परिश्रम करले आपण in your day.
Your lordship please just fix the date.
केबे चाहू April.
Lordship, please.
April and March.
My lords, as your lordship, according to the
week commencing, listen the week commencing 6 चाहे. वो 3-4 पर रहेगा को डाउट किछ रहला कि जा जरा मते देखैले आपण आनिले सेटा को सा रिसीव करिवे आपण को एंडोर्समेंट भी कर देबे आ जोटा फोटोकॉपी रे रिसीव करी कि आपण साउ सर को दे देबे से आपण रिसीव करी देले यस ଆପଣ ଏଟା affidavit ଫାଇଲ କରୁଛନ୍ତି
payment
ଏଇଟା ଆଜି ଫାଇଲ କରିବେ ନା ପରେ କରିବେ ନା କଣ ଆପଣ କାରଣ ଏଟା ମୁଁ ରେକର୍ଡକୁ ଆକ୍ଚୁଆଲି ନେଇନି ଇଟ୍ସ ୟୁର ଚଏସ୍ ଯଦି କରିବେ ତାହେଲେ ତାଙ୍କୁ ଦେବେ କପି ତାପରେ
ତାହେଲେ ମୁଁ କାଉଣ୍ଟରରେ ଫାଇଲ କରିଦେବି
ଠିକ ଅଛି ଇଟ୍ ଇଜ ସବମିଟେଡ ଆଉ ଲାଇନ ଆଡ୍ କରନ୍ତୁ ଇଟ୍ ଇଜ ସବମିଟେଡ ବାଇ ମିଷ୍ଟର ଲର୍ଡ କାଉnsel ମିଷ୍ଟର ସାହୁ ଫର ଦ petitioner that
କାଉଣ୍ଟରରେ ଫାଇଲ
the petitioner shall file affidavit. His copy of the said affidavit shall be served on the Lord Counsel for the petitioner, for the opposite party. For the opposite party, scan copy be affidavit shall be taken on record. Scan copy be updated. तापरे डेट कर देंगे और पासवर्ड रहे लगी yes thank you